as I was just mentioning, this is one of the, for lack of a better word, crazy weeks of the center. We have about 4-5 events going on. So even I will be shuttling quite a bit, but I'll try my best to make the time for today here. Okay. The meeting is being recorded. My mouse doesn't move to say yes. Okay, so for those of you who are coming from outside South Africa, well, welcome to Pretoria, or if you're coming from outside of Pretoria, welcome, and thanks for bringing the thunder and rain through the night, because apparently yesterday was quite some noisy night for those who were around this place. It's in many ways, today's gathering is a gathering of friends and colleagues. We are not really new to each other, but I think the most significant part is that we are somehow, through our work, our professional engagement, our various career our trajectories, have interacted with Professor Charles Ngwena at one point or the other, and in various capacities. And in many ways, I feel that this is already a testament to the significance of Professor Ngwena's work, that each of us can claim a strand of relevance or relationship with the work that he has done. So I'm hoping that, as we have the 2 days of reflection, we will be thinking, of course, about the many realities of our sexual and reproductive health rights context on the African continent, which I think we can characterize in different ways. But in many ways, I think a lot of us can agree that we are we are experiencing a strong pushback on aspects of sexual and reproductive rights. We have a lot of denialism that surprisingly is re-emerging on certain aspects of rights. We have some even, say, revisionist narratives around sexual and reproductive rights. So in many ways, it is a bit of a perilous time for sexual and reproductive health. And this, to me, brings forward the significance of pioneering works and pioneering scholars such as Professor Ngwena, because the work that he was doing, he has been doing over the years up to now, is work that really is born out of courage and passion. And I think it's a courage and passion that we seek to emulate. Those of us who are coming after him and learning from him, we hope we can emulate and continue to further in this field. Sexual and reproductive rights is not about to stop being a controversial subject, particularly in the African context, and where we live in cultures that continually problematize the sexual and reproductive health rights of people, and also where aspects of vulnerability are stigmatized. And so it's very important that in this conference we are able to capitalize on aspects of work that are so unique, looking at vulnerability and human rights, which is something that Professor Ngwena has done very well as looking at a largely neglected area of rights, which is sexual and reproductive rights. So while we'll be exploring many themes, I hope that we will be able to have time to reflect and to appreciate, and also to look back at what has been done so that we can know what we are doing in the future. I think we know also that even if Professor Ngwena's work is mostly academic or has been rooted in the academic sphere, it has largely transcended the academia, and a lot of us have also interacted with him and his work out there in the field. So I think for me, I look forward to a very interesting 2 days ahead, and I'm also looking forward to reconnecting and to new insights and to profound learning in these 2 days from all of you, your experience, your research, your interest. Yeah, often at times we get a bit uncomfortable talking about people when they're in our midst. It's not very African. We tend to like to talk about people when they're not there. But this is a different approach. We are celebrating for Professor Ngwena when he's still a member of our faculty, when he's still part of the work that we do. So I am very, very glad to be part of this initiative. and to celebrate the enormous contributions of one of us in this field, in the African region and beyond. So I welcome you, and I look forward to meeting all of us and to engaging and celebrating the work that of sexual and reproductive health and rights, and all the intersections that we'll be looking at, including women's rights and disability rights. It's a pleasure. Welcome. Before I sit, I would want to request, just for brief remarks, our Deputy Dean, Professor Charles Ngwena, who is sitting right there at the end. He's also not in our mainstream. I don't know why, but Professor Ngwena will speak, will just make a few remarks. Let me just say, because I put him on the spot, that I must apologize, because we reached out to him quite a bit late because of other factors that I cannot state here right now. But he nevertheless made a point to come, and for that we are truly grateful. Thank you very much, Professor Ngwena.
Thank you very much. Good morning, colleagues. Those who
morning.
Oh, okay. Those who are online and also in the auditorium, as they said, you even heard that I'm being abused. It's the joys of being a deputy to somebody. When you're a deputy, you're just being tossed around, and the invitations come and you must run. So you must split yourself into a number of pieces, but that's not an issue. I'm used to it. But thank you to the colleagues at the Center for Human Rights for this great gesture to our colleague Charles, and also to celebrate the work Charles is doing in the faculty, and also that his students and colleagues also celebrate the body of work which Charles has engaged in. And some of the body of work which Charles has engaged in is one of the things which we as a faculty were taking forward in our strategic plan of building an inclusive faculty. And we believe as a faculty that there is strength in diversity of people from different walks of life. So we are really greatly indebted to scholars like Charles and also the colleagues at the center for taking these great initiatives, that we don't only speak about how good people were at their funerals, because we tend to lie in most cases there because of the moody, somber, and all sorts of things, but to engage with people while they are alive and celebrate their milestones while they are alive. And I believe also as a faculty, we'll take that forward to call Charles formally again in the faculty, that the broader faculty also is there to celebrate with him about the great work which he has been doing in terms of his body of scholarship, disability rights, sexual and reproductive rights, among others. So Charles is a pioneer in that area. But my job is quite easy: to welcome people to the #1 law faculty, Professor Albertine. Welcome to the hub of greatness. We know you are vets. We hope you'll take a leaf of greatness with you as you leave. Colleagues from UNISA, from also in the continent, I saw in the list there, welcome to the hub of greatness. We are #1. We are not taking chances. 7 years in a row, and we are now 65 in the world. So next year will probably be #1 in the world. So it's an exciting time to live, and it's an exciting time for you to be associated with the #1 law faculty in the continent. There's no competition in South Africa. We've already addressed that score, and we're still humble about it. That's what makes us #1, because we are humble. But one of the great strengths our faculty is really tapping on is our humanity. Our faculty is tapping on the aspect of humanity in such a way that we, as a faculty, are able to relate as human beings. Because the moment we are able to relate as human beings and we become respectful, despite of our diversity and diverse backgrounds in terms of the history of this country and the continent, we can be able to start to relate, and naturally we'll start to work together. We are a faculty that believes that transdisciplinarity and multidisciplinarity cannot be a policy directive, but it's something which must rest within human beings. The moment they relate, it becomes better and naturally for them to collaborate and to thrive in their respective fields. So from the side of the Dean of the Faculty of Law, Professor Elsa Biskuman, who's unable to join today, and on behalf of the broader MENCO of the Faculty of Law, we welcome you and we wish you success in this 2-day of the conference, and we hope you will live enriched and also being able to make a difference in the lives of people, because that's our job. We need to ensure that we make a difference in the lives of our students, the communities which we come from, because the work of Charles is an embodiment of that, to make a difference. And we have to, as you leave tomorrow and close the conference, you must also ask yourselves, what difference are you making in your respective communities, in the lives of the students, as you celebrate this great giant, Charles Ngwena. From the side of the faculty, I'll also try to come through, particularly for the cocktail and stuff, to enjoy a bit of cocktail. I'll teach myself how to drink alcohol, because I'm still lagging behind in that score. But thank you very much, and I wish you success and enjoy your day and 2 days of the conference. Thank you very much, colleagues. Bye.
I just came back to once again say thank you to him, but also because I skipped an important part, which is to also welcome our participants online. If you're not here, that sometimes we are still steeped in the pre-COVID world where we only thought about people when they are where you are. But actually, this particular conference is trying as much as possible. It's actually only possible because we were able to do it through a blended format. Because as you can see, our main character of the party, our main recipient of this honor is actually not with us physically, because he has been for some time attending a research fellowship at Yale, and he was not in a position to travel. So he will be joining us virtually a bit later in the day also, because you can appreciate the time difference. I'm sure he's still sleeping, but he will join us in the course of the day. So thank you very much to all of you who are joining us online. We will, as much as possible, try to keep this interactive. And we also hope that you can please be interactive. Let us know. We are monitoring the online platform. Please let us know if you need to speak to us. Is that? No. Okay. Thank you very much. And thank you, Prof. Maimela. And yeah, we are celebrating your compatriot. So maybe it's by extension. Thank you. I think now I will hand it over back to Satam.
Good morning, everyone, and thank you for being here with us. Just to say, we'll take about 5 minutes break, and we'll be back with the first panel, and I'll go through the program when we're back. So 5 minutes, and we'll be back. Okay, thank you. The first panel on breaking barriers to safe abortion access in Africa. And we're very honored. I know the Deputy Dean did obviously spotlight you, Professor Kati Abantine, who is the Professor of Law and Social South African Research here in Equality, Law and Social Justice in the School of Law at the University of Wits. Prior to joining the school, she was the director of the Center for Applied Legal Studies and headed its gender research program for 10 years. During this time, she also worked closely with the women's movement in seeking to influence the constitutional negotiations, and after 1994 on several policy and law reform processes. In 1997 as well, she was appointed a commissioner on the first Commission on Gender Equality. And just a personal additional note, she also has an incredible archive, which I was able to access, especially as it relates to the book project that we'll talk about tomorrow as well. Please join me in inviting Professor Kathy Albert. Yeah. Okay. Perfect. Sounds good. Yeah.
Okay.
Yeah.
Thanks so much, Satang, and hello everyone online. And Charles, I believe you're not there, but I want to nevertheless, hoping that you're going to watch this a little bit later, just pay enormous tribute to you and your work and your huge intellectual footprint, particularly in Africa, but also I think your capacity building footprint and the role that the Center for Human Rights and your program here has really played in sending people out to Africa to do the work. And when I was thinking of preparing for this fantastic panel that really draws people from across the African region, I have to remember that Africa was really the first continent that set really impressive continental standards in the African Women's Protocol in 2003, I think. Way ahead of any regional or international treaty in terms of the standards that it set for women's rights. And I still think actually ahead, although I know some interpretations by human rights bodies and treaty bodies have gone a little bit further, and there is a little kind of soup song of abortion on request in some international norms. So just a little bit ahead of Africa, maybe. But I really think Africa set the standard and everyone else has been playing catch up. That being said, I think African countries have been playing catch up with the standards that were set in the African Women's Protocol. And that's really, I think, what we're going to hear about today is how the different regions in Africa, where they are at this particular point in time in terms of safe abortion access. And we have a wonderful panel of 5 people. 2 people are online, 3 are here in person. I don't have bios, so I'm actually going to ask each of you just to introduce yourself very quickly at the beginning. And after that, I'm going to take Professor Irene Muffy first, because I know she has to go. And then we're going to go in order. So Sayo Tabitha is also online, and the other 3 are here with us. But Sayo, Tabitha, I wonder if I can ask you just to switch on your camera and your mic and to briefly introduce yourself. We know you from the East African region.
Thank you so much, Prof. And I'm very happy to indulge Irene or anyone else who needs to go ahead of me. My name is Sayo Tabitha Griffith. I am a lawyer by profession from Kenya. I am switching on my camera today from Nairobi, Kenya. But more importantly, the fun nuggets of who I am is that I am a Pretoria Mafia, meaning that I was in the same class as Satang. Don't ask me why I do not yet have my PhD. I am miserably failing in that department, but Satang reminds me constantly that I need to complete my PhD. So I am here in my capacity not just as an East African who has been working more than 12 years on access to safe abortion in Kenya and East Africa, Uganda more particularly, but I'm also here because I am paying tribute to a man who really steered me in this direction. Thank you.
Thank you. And then next is Crispin Sabanda, who is here in person. Okay, so the camera, can you maybe put the camera on him? And then please go ahead, Crispin.
Good morning, everyone. My name is Crispin Sade from Malawi.
Yeah. Yes, we can. Yeah.
Yeah, I've been working on issues of access of abortion in Africa for more than 12 years. I am currently a member of the UN committee on elimination of racial discrimination, and also an executive director of Center for Development of Human Rights and Programs in Malawi.
Thanks, Crispin. The next is Dr. John Gardner.
So my name is John Ngwena, and I come from Ghana, and I work for the University of Public Health. Basically, I do research on sexual reproductive markers and essentially sponsored populations on community spaces. But I also heavily involved in the effort at a country level to institutionalize the profession. So we do assessment of service and
and then fourth is Irene Muffy. Professor Irene Muffy, do you want to go ahead and introduce yourself?
Good morning, everyone, and thank you so much for inviting me to take part in this conference. I'm very honored. I wanted to come, but unfortunately it was 40 hours trip, so it was a bit difficult for me to come. And I just wanted to say that I cannot hear very well when you pass the microphone to the colleagues who are sitting over there. So for me, I don't know for other people online, but I couldn't hear their voices very well. And I apologize because I'm actually on sabbatical and doing field work, and I have to go, but I will come back later and try to attend the rest of the conference for today and tomorrow. So I apologize for not being able to stay this morning. So, and I am a professor of social anthropology at the University of Lausanne, and I've been working mainly in the Arab region and in the last few years also in North Africa, so in Tunisia particularly. So I will today speak about the situation of abortion access in the North African region, so what is called Maghreb, also the Arabic term.
Thank you. Sorry, okay, we'll just take one more introduction, then I'm going to come back to you for your presentation.
Of course.
So Dr. Bilgisu Balde is our
Hello everyone, can you all hear me well?
Doesn't look like it.
Hello everyone, can you hear me online? Perfect. Hi, I'm Bilgisu Balde. I work for IPAS, Partner for Reproductive Justice, as the Regional Director for Francophone Africa. I'm based in Ivory Coast right now, and the company that I'm leading as well is currently incubating ODAS, which is the Organisation pour le dialogue pour l'avortement sécurisé, which is the first regional feminist movement entirely dedicated to strengthening the safe abortion movement in Francophone Africa. I'm really glad to be here. In my work, we do cover over 12 countries across the Francophone region, working on reproductive justice, safe abortion care, and all of the intersectional areas, including gender-based violence, humanitarian emergencies, comprehensive sexuality education, as well as disability rights. Thank you.
Thank you. All right, so assuming this is what I have to talk in now, I'm going to be hearing from this one. I'm going to hand over to Professor Irene Muffy. The way it works, I think, is that each participant has, I think, a minute to debate. I think I'm going to switch on my camera when we've got about 2 minutes to go. We need to try and keep to time because we have 5 presentations. And then we have about 5 to 7 minutes, I imagine, for Q&A after each session. And then if there's time for general Q&A, we'll do it, but I'm not sure we'll have that kind of time. So I think that's to you.
Thank you. So I will start with something you already mentioned. So we might remind you that since the International Conference on Population and Development in Cairo in 1994, sexual and reproductive health and rights have been recognized as key parts of the International Development Agenda. They now form part of 2 Sustainable Development Goals, number 3 on good health and well-being, and 5 on gender equality and empowerment. Although the ICPD's final report did not recognize abortion as a woman's right, it emphasized that in the countries where it is legal, women should have access to safe medical procedures and that more research should be undertaken to understand the phenomenon. Many policymakers and scholars recognize the legalization of abortion as an essential step to reduce maternal mortality. When governments restrict access to abortion, abortions continue to take place at roughly the same rate. Restrictive anti-abortion laws are associated with high rates of less safe or least safe, as they are called, abortions, and are therefore seen as determinant of maternal mortality. However, only the protocol, as you remember, to the African Charter on Human and People's Rights on the Rights of Women in Africa from 2003, so the Maputo Protocol, recognizes abortions as a human right in specific circumstances. For example, sexual assault, rape, incest, or when the continued pregnancy endangers the mental and physical health of the mother. Now, only a few North African countries have signed or ratified the Maputo Protocol, and those few have done so only very recently. In 2015, Beji Essebsi, then president of Tunisia, signed the protocol, but Tunisia did not ratify it until 2018. And laws have yet to be harmonized according to its principles. Sudan has signed but not ratified it. Algeria officially ratified the protocol in 2016, but its application is problematic as abortion, in the cases indicated above, is not considered a human right under the country's laws. Mauritania ratified the protocol in 2005, but it has not changed its laws. Abortion in Mauritania is still criminalized under Article 2093 of the Penal Code. Egypt, Morocco, and Libya have neither signed nor ratified the protocol. The impact of abortion bans on women's health in North Africa is understudied, and reliable data on unsafe abortion in countries where access to safe abortion is difficult or non-existent is lacking. The reason is that states where abortion is illegal do not collect data on that topic, or at least do not make them public, because social and political issues constrain epidemiological studies related to abortion. However, a 2008 World Health Organization report estimates the yearly total of unsafe abortions in North Africa to be 900,000 and causing 5,000 at least, and I think it's really underestimated, annual maternal deaths. Overall, the report estimates the total number of maternal deaths in Arab countries, not just in North Africa, to be 40,000 in 2007. Wars and displacement in the MENA region also contribute to high levels of maternal deaths, some of which are probably still related to unsafe abortions. So the Fragile States Index produced by the Fund for Peace currently places 5 MENA countries, among which Sudan, on very high alert or high alert. And we also don't know anything, for example, about Libya, where the situation is really, really difficult, suggesting that these factors are likely to continue to affect maternal mortality in the near future. Very few publications exist on abortion in the MENA region, not only in North Africa, and those that do exist tend to either give a broad overview of the legislation of different states or evaluate Islam's position on abortion. Detailed fieldwork-based studies on actual medical practices, political debates, local legal implementation, moral and social norms, and the trajectories of individual women in North African countries are very rare still. All countries in North Africa are Muslim majority countries. Now, Muslim majority countries reflect remarkable variations in abortion legislation, and religious scholars diverge notably in their theological reasoning. So, however, all countries in the MENA region, and this is a good point, permit abortion if the pregnant woman's life is in danger. This resonates with Islamic jurists who have historically perceived abortion as generally forbidden, haram, after the fetus achieves ensoulment, so the status of a person, except to save the woman's life. In North Africa, abortion is allowed if there is a risk to the pregnant woman's physical health, for example, in Libya and Morocco. If there is a risk to the pregnant woman's mental health, for example, in Algeria and Morocco. If there is a fetal impairment, like quite recently there is a new law in Morocco and Saudi Arabia. And also in case of rape, for example, in Morocco and Sudan. So not all states, although they are Muslim majority countries, have the same kind of legislation. Most abortion laws in the region are punitive and were promulgated during the colonial period, when French and British regimes supported pro-natalist policies to increase the population of the metropole and of the colonized lands. As colonial laws criminalizing abortion became entrenched in society, legal and medical services for women desiring abortions also became restricted. Nonetheless, according to a famous scholar who has been working on sexuality also historically in the Arab countries, Basim Musallam, abortion was widely practiced in Islamic societies during the colonial period, so still during the colonial period, and the main Islamic scholars had different opinions on abortion. Some authorized abortion until 120 days after conception, whereas others were opposed to it completely. During the 19th century, progressive interpretations of Islam and demographic concerns, coupled with a desire to lower maternal mortality rates, led to laws allowing for abortion on demand during the first trimester. For example, in Tunisia, Tunisia is still the only Arab country, so also of course in North Africa, located in North Africa, which allows abortion for social reasons with no restriction. However, because these laws were designed not to extend women's rights, but to decrease natality rates in many countries, they are often applied, or were at least in the past, often applied in a coercive way. So in several countries in North Africa and more largely in the MENA region, and Tunisia is one of them, cuts in government health expenditures and the emergence of conservative religiously oriented parties, especially after the revolution of 2011, have contributed to the restriction of publicly provided abortion services. So, for example, the case of Tunisia shows that legalizing abortion is not enough to grant equal and easy access to abortion care, especially for unmarried women from lower socioeconomic classes. Although in Tunisia, so unmarried women have access to abortion care, at least theoretically. Let's take the case of Sudan. In Sudan, and I'm not, of course, speaking about the present situation, which is really tragic, but before the civil war, abortion was politicized through its association with illegal pregnancy. Fornication is a crime against God, punishable with 100 lashes, and pregnancy outside a marriage contract constitutes sufficient evidence of a woman's immorality. This enables a strong link between the crime of fornication and the crime of illegal abortion. Abortion doesn't normally appear in the domestic political debate didn't appear on domestic political debate on women's reproductive and maternal health. However, it has become politicized in the context of Islamism and militarism in the country, as implementing strict Islamic law often puts control and suspicion of women's sexuality at center stage. In addition, a number of bureaucratic barriers, as well as a strong police presence outside maternity wards in public hospitals, make it difficult for unmarried women to access emergency care after complications of an illegal and often unsafe abortion. Doctors who treat unmarried women suffering such complications are forced to maneuver between their commitment to medical ethics and their compliance with strict government laws and policies. So it's a complicated situation. In Morocco, criminalization does not appear to be an insurmountable obstacle for women who want to safely terminate a pregnancy under medical supervision. At least for those women who can afford to pay, it seems relatively easy to access abortion care, and most abortions take place in medical facilities with qualified clinicians. Interestingly, in Morocco, rural and poor women are still victims of high maternal mortality compared with the urban population. This is because although abortion is illegal in Morocco, it is widely performed by local health providers. Nonetheless, while women who can afford it can easily get abortion care in the main cities of Morocco, and married and marginalized women may find it impossible to pay a doctor to perform an abortion. Many such women will therefore try to abort through more or less traditional methods, including herbal medicines, mechanical methods, and cocktails or biomedicine. I don't know if you heard that last year in October, a very young woman, 15 years old, died after trying to get an unsafe abortion. And so there was a kind of mobilization among some associations and struggling to legalize abortion. And this one was the victim of rape. So most women of low social class or living in rural areas keep their pregnancy and in the last 10, 15 years are able to receive some protection from the Moroccan non-governmental organizations that take care of unwed mothers, a category that has gained visibility in the last decade. So these local organizations, there are some studies about it, have produced a new moralizing discourse on abortion that coexists with the legal sanctions. Although the notion of sexual and reproductive rights has been introduced in Morocco, abortion is not considered part of these rights. Furthermore, the state does not recognize unwed mothers as a specific group because the law does not recognize filiation outside of wedlock, and premarital sexuality is socially and legally condemned. As I told you, in Tunisia, abortion has been legal since almost 15 years, and it was legalized because at the time, after independence in the late 50s, early 60s, the new government, the new state wanted to lower the natality rates that were very high because they adhered to a neo-Malthusian rationality. And this abortion and often also contraception were applied in a coercive way, especially for poor women and women living in the rural areas. But it, of course, had very good effects because it allowed access to all categories of women, starting from 1973. So it was only after the revolution of 2011 that some problems emerged because of conservative ideologies, and also because there were, and this is a paradox, the abortion law was not anymore implemented as during the autocratic regime of Bourguiba and Ben Ali. And so health providers were quite free to decide if they wanted to offer abortion care or not. So paradoxically, the democratization of society in Tunisia brought about less reproductive and sexual rights for at least some categories of women, especially those who access public, so government healthcare infrastructures, centers. As for Egypt and Libya, so we absolutely have no studies, as far as I know, about Libya. We only know that the law in Libya so bans abortion. It is prohibited according to the Penal Code, Article 3019 to 3095. And it is also impossible for women who were victims of rape to get abortion care. It is only performed to save the honor of the person who performed it, so the doctor or a relative of the woman, but not in any case for the condition of the woman. And as for Egypt, also we don't have a lot of studies. The one we have are quite old, but the law in Egypt is very restrictive. At least theoretically, it can be, so abortion can be performed to save the woman's life, but it's not very clear under which circumstances and in any way it is necessary to get the authorization of at least 2 doctors to be able to perform an abortion on a woman whose life is endangered. And also the abortion law in Egypt was implemented during colonial time. It is so lately there were some local NGOs which tried to push for the legalization of abortion, but with no success. So I would say, to conclude, that the situation is not particularly positive, and it doesn't seem to go to the right direction in North Africa. So I didn't also quote the fact that in Morocco there were already in 2014, 2015 an attempt to legalize abortion that failed, and since then nothing happened. So, and I will conclude here. Thank you.
Thank you. Thank you very much. Thank you very much, Professor Ngwena. That was fascinating. I knew nothing about North Africa, and the variation is, I suppose, makes sense. Is this mic working?
Is it on?
Switch it on. Is this working on? Yeah. Okay, good. Sorry, just to go back, thank you very much. That was absolutely fascinating. The variation is fascinating and probably rational if you understand it in terms of simply versus religious states. But really interesting when it comes to the region. Are there any questions for Matthew, either online or in the room? That's okay. Okay, then I'm going to just express my question a little bit about the pattern across the region. So would it be correct to say that the more secular states, if that's a fair description of places like Morocco and Tunisia, we have a history of women's rights legislation. So the nature of the state versus, I don't even know if it works. Maybe it works for Morocco, it works for Egypt. Would that have something to say with the pattern of women's rights in the region, or are there other factors operating outside of religion versus secular state, or straight religion, kind of?
I'm really sorry, I cannot hear you clearly. I can't hear. I don't know if the microphone is.
Maybe you should talk to yeah. Talk to Zoom.
Okay, so Irene, can you hear me now?
Now, yes. Sorry, I couldn't hear you.
So are there any other questions? No. Okay, so I've got one question for you, and it's really the pattern of abortion rights across the North African region and the extent to which it's related to the nature of the state, which is the more secular states are more likely to protect women's rights and enable abortion rights, and states which are possibly more religious or where conservative interpretations of Islam predominate are less likely. Would that be an accurate reflection of a pattern across the region that you're seeing? Or would there be other factors at play, like the strength of NGOs, the sort of the individual histories of the region or of the country?
Actually, I think, if you think, for example, let's take the example of Egypt. So Egypt didn't have a very religious, it was not a religious state for a long time. So after independence, it was more, a socialist state. Also, Algeria was more for several decades a socialist state, not, presenting itself as a religious state or inspired by Islam. And in spite of that, their laws were very restrictive. So I don't think it's there is an immediate, it's a very direct connection between religion and the secular, and the secular nature of the state. And also, if we think of the case of Tunisia, where actually the legalization of abortion was justified religiously, actually, because in Islam there are several juridical schools, and some of these schools allow abortion until 120 days after conception, because they think that ensoulment of the fetus happens after 120 days. And so you can justify abortion religiously. And this is very interesting because the Tunisian state was also a state which did not want to be a religious state, but it justified many of its reforms, which were quite progressive during the 60s, through religion. On the other side, Egypt or Algeria, which after independence were quite secular, didn't change their law, didn't make reforms that, for example, give more rights to women because they were secular or socialist. So I think it's more complicated.
Thank you. Okay, it's always more complicated, but actually Tunisia is a fascinating example of that complication. There are a couple of comments in the chat and really people wanting to know more around literature. So I'll leave that. Satang has spoken about a book project that Irene has written, and some of the other presenters have chapters. So there will be more on these kinds of studies appearing. So I think I'm going to move on then to the next presenter, who is also online, but now I'm worrying, is it Tabitha Sayo or Sayo Tabitha? Because So I'm sorry, I don't know which way around it is, because on your Zoom, it is the other way around to the program. But anyway, we have met you already, so please go ahead and share your presentation with us.
Thank you so much, Prof. The names are all mine, so I accept them in whichever order that they come. Tabitha is always the easiest, so that's why I always put it in the at the beginning. I am making this presentation on behalf of myself and on behalf of Nerima Were, my colleague, because as Satang pointed out, this was a joint project and the two of us were representing Kenya. So I am going to try as much as possible as I share my screen to take very short time. However, as Satang said, the full picture and the more comprehensive presentation is going to be made, or rather the more in-depth meat of our work is in the book chapter. So because of the limitation of time, I want to first start by asking colleagues to bear with me if I'm really fast in how I speak, and if I glance over some of the really important things. But it's not to say that I'm dismissing them, it's just to say that because I have been given a really limited time slot, we really must do this. Try and compress 8,000 words into a 20-minute presentation. Just to let you know that unlike Professor Irene Murphy, who has discussed around North Africa, or rather the MENA region more broadly, our presentation will focus on Kenya as an example of the East African context. So for those who are from Uganda, Nigeria, Rwanda, Burundi, Tanzania, Uganda, I'm really apologetic that I am masquerading as a representative of East Africa, but our presentation really honed in and zoomed into Kenya as an example of what are the existing laws, what are the policies that we have, what are some of the court wins that we've had more recently, losses, as well as what is the rising challenges that we're seeing in a climate that is now fueled by what we call either anti-SRH challenges or anti-gender actors, depending on where you're coming from. So just for purposes of you to get a sense of what I'm going to present and how our paper is structured, one, it's just to introduce the participants into the historical context of where does Kenya get its abortion laws from? And in this instance, I'll be discussing a time frame of 1963, which is when Kenya got its independence, to 2009. And the mark stops at 2009 because that is now when 2010 got a new constitution. Then after the new constitution, the promulgation of a new constitution, there's the new dawn, the dawn of Article 26.4, which is then enshrined into our constitution. And the biggest questions that we've had as Kenyans and as people who are studying the patterns of legal jurisprudence here is, what then changed with Article 26.4 coming into the Constitution of Kenya? I'll try as well pull out a little bit of the jurisprudence that compares how cases were prosecuted before 2010 and how we've seen cases being litigated before the Constitutional Court post 2010. And then I want to end with just showing and sharing with the people that even though we do have this beautiful judicial precedents that's coming out, there's also an advent, a new rise of a trend of anti-SRH actors that are really trying to claw back every single gain that we've made. And I think it's important that I'm not just sharing the legal ecosystem, but also indicating and displaying to the people who are listening in around what does the social, what is the true feeling on the ground, what's happening right now. And then in conclusion, just share with you very quickly the proposed amendments that we're seeing from the National Council for Administrative Justice. So between 1963 and 2009 in Kenya, like many people who inherited, like many British colonies, Kenya inherited a penal code that criminalized abortion. Abortion in Kenya is criminalized under sections 159, 158, 159, and 160. And there are three types of people who are criminalized under those three sections, 158, 159, and 160. Number one, there's a criminalization of the woman. There's a criminalization of those that aid the woman, and then there's a criminalization of the medical provider. Those are the three types of people who under 158, 150, 160 are penalized either by a 7-year jail term or by a 14-year jail term. The penal code, however, notably, just like many of the African countries, and when I say we inherited this, comparatively, please look at the penal code of Zambia, Malawi, Uganda, Nigeria, Ghana. We have almost the same provisions when it comes to termination of a pregnancy. The most interesting thing for the Kenyan penal code is that there is an exemption, and that exemption was provided for under Article 240, rather Section 240, let me call it Section 240 of our penal code, that was the saving grace between 1963 and 2009 for a lot of medical providers. Section 240 provides that a person will not be criminally responsible if they perform in good faith and with reasonable care and skill a surgical operation upon any person for his benefit and upon an unborn child for the preservation of the mother's life. For those who have engaged with obstetricians and gynecologists from Kenya, this was what many of them would use between 1963 and 2009 in instances of saying this woman needs safe abortion. But the limitation under that was that they had to demonstrate, first of all, that it was for the preservation of the mother's life, and that was it. And therefore, when you speak to the older medics in the profession, they'll tell you that this was one of the biggest hurdles that they had in terms of justifying how was it for the preservation of the mother's life, and was it performed with reasonable care, right? So there was a lot of due diligence that came with the exemptions under Section 240. In this same era, between 1963 and before 2009, what was, however, interesting is that Kenya had, under the Ministry of Health, guidelines on management of sexual violence in Kenya. And one of the things that the guidelines acknowledged is beyond the saving of the woman's life if the woman was in danger, it allowed for survivors of sexual violence to terminate a pregnancy and get post-abortion care. Please note that the language that was more favorable in terms of, because I always insist that we must also not only look at the law itself, but the language that was more palpable and acceptable was the language of post-abortion care. So many of the documents that were coming in from Ministry of Health were not directly saying that women could access comprehensive safe abortion care in the first instance, but many of them spoke in an option of post-abortion care. The most notable litigation, there are two cases that I would perhaps want to indicate during this era, right? The first one is the 2005 case, a High Court case, Republic versus John Nyamu. And this is a case that is very interesting because of the fact that the medical provider in this instance was not charged with Articles 158, 159, or 160. Dr. John Nyamu, who is a medical obstetrician and gynecologist, was actually charged with murder. And in allowing for the freeing of Dr. Nyamu, Justice Kalpana Rawal examined the question of when does a child become a person capable of being killed, right? Because the charge was not one for abortion, it was rather one for the murder of a fetus, right? And therefore, in her decision, and I'm happy to share this for anyone who is interested, in this instance, we see the demonization of Dr. John Nyamu, but he's also charged under murder, not under the provisions of 158, 159, or 160. And in letting go of Dr. John Nyamu, Justice Kalpana Rawal then argues that I cannot find any evidence in this instance that would be, make the connection between when a child becomes a person capable of being killed in law, right? Because the important ingredient was, has the child completely proceeded in a living state from the body of the mother? I will not interrogate this further because of time, but I would love to have, a conversation with people around what we're then seeing right now, which is the flip side of the question of the human rights of fetal rights and the question of the right of the unborn, right? The second case that would be of interest to those who are litigators or those who keep track of judicial precedents is the appeal by Elnora Kulola Ilonga. This is an appeal that happens in 2007. The decision is made in 2009 at the Mombasa High Court. In summary, the case is about a woman who takes an anti-malarial drug when she is pregnant, known as Fansida, and she then is charged under Section 159 of the provisions of the Penal Code for the intent of procuring her own miscarriage. And she appeals because she is convicted at the lower court, but she appeals to the High Court. And in setting her free, the judge also argues that there is no sufficient evidence to show that Kulola had an intention of procuring the miscarriage. That for her, she genuinely took the Fansida anti-malarials with the belief that she had malaria and therefore she was curing herself. So what we see in both High Court decisions is that we're not seeing any convictions that are succeeding, and women are not actually being convicted, or rather, even if there is any conviction at the higher courts of precedent setting, no courts were prosecuting. There was no appetite or there was no interest in prosecuting women who had gone through abortion. Enter 2010. We then give ourselves as Kenyans a new constitution, and in that constitution, one particular clause stands out. That is Article 26(4) of the Constitution of Kenya, which says that abortion is not permitted unless, in the opinion of a trained health professional, there is need for emergency treatment, the life or health of the mother is in danger, or if permitted by any other written law. There are many interpretations that have come out right now around what exactly 26(4) allows. But where the consensus has been is that, number one, Article 26(4) now expanded the definition of who could offer safe abortion services in Kenya, because the definition of who a trained health professional under the Health Act includes not only the medics, that is the ones who are the obstetrician gynecologists, but also extended to nurses, midwives, and clinical officers. And that's an interesting thing, because then it allows for a wider range of trained health professionals to offer the services. Number two, the circumstances under which a woman could have safe abortion services is extended beyond what we know in the Penal Code under the saving grace of Section 240. Because in this one, it says where there's need for emergency services, the life of the mother is in danger, the health of the mother is in danger, or if permitted by any other written law. And for us, those of you who have at least interacted with the Kenyan Constitution, you know that we do have Article 2.5 of the Constitution of Kenya that talks about ratification of international documents and the acceptance that any laws that are ratified at the international space automatically become part of Kenya's laws. So this is while the acceptance of our constitution, this was a make or break situation, and abortion was one of those highly contested spaces within the making of our constitution, we then see a really progressive Article 26(4) that then gives us a lot of wiggle room, both as women, as the medical providers, and also the circumstances within which women can get safe services. Beyond the constitution, we then see a Ministry of Health that is extremely progressive. We see them launching in 2012 standards and guidelines for the reduction of maternal mortality. We then see them actually going ahead to also amend their national guidelines for quality obstetric and perinatal care. And we see very bold language in guidelines and other legal documents when it comes to access to safe abortion. So for instance, you will be able to see in the national guidelines for 2012, the language that is used is one that says post-abortal care is care that can be given when a woman has had an unsafe abortion, a spontaneous abortion, a legally induced abortion, right? And this is positive language, and we see a lot of less demonization in the guidelines. 2013, during the era of President Uhuru Kenyatta, we also see the introduction of free maternity services in Kenya, But what is of interest, and I'm sorry that my slide may not be very visible to those who are physically in the room, is number 2 in this memo, which says that postnatal care is an integral part of maternity services and should be treated as such, and therefore should be charged as delivery. This means, and what we saw in practice, is that postnatal care became free of charge. So the same costs that would have been associated with a delivery, women delivering, were also given to women who needed postnatal care. And this is what we'd call, like, if this was, you know, a chart, this is the peak of our graph in terms of just how acceptable safe abortion is in terms of health directives, in terms of the law, in terms of the constitution. And at the peak of this in 2017, we then see a health act that defines health to be a complete state of physical, mental, and social well-being, and not merely the absence of disease, and a section 6(2) that then says that for purposes of safe abortion, the term trained health professional refers to, right, a doctor who has formal medical training to the level of a medical officer, a nurse, a midwife, or clinical officer. And as I emphasize this is because we came from a space where the only person who was legally allowed to offer abortion was a medical officer who had been trained in obstetrician and gynecology, and for whom they had to get at least a second opinion from a psychiatrist. We now see a more liberal space where women can literally, they don't need you know, a psychiatric evaluation, and all they need is that trained health professional. Because of devolution, which is one of the benefits of the 2010 constitution in Kenya, we also see increasingly some counties coming up with their own maternal, newborn, and child health acts that are quite liberal. Makueni County, for instance, allows for women under Section 6 to terminate their pregnancies if it poses a risk, right, to the health of the mother, if it is for substantial risks to the fetus that they would suffer abnormalities. And we also see as a result of sexual assault, defilement, rape, or if they have a mental impairment that makes them incapable of appreciating a pregnancy. What is most critical to the liberation in Makueni County is that under Section 6(2), the Makueni County Assembly says that a statement by the pregnant woman is sufficient proof, especially when she has been raped, and does not need to further prove, as for those of you who appreciate, I think, the leading case in Zimbabwe around how much proof do you need as a woman who has been raped to be able to access safe abortion. So this is really at the peak of liberation of safe abortion in Kenya. At this instance, we also see our courts post 2010 coming up with very, you know, progressive jurisprudence. We then see 2 cases which are currently before the Court of Appeal, and therefore I will limit my interaction with them to what was decided at the High Court. We see the JMM case, which is the first case, petition 266 of 2015, interrogating the role of the Ministry of Health when they take back the standards and guidelines, and equally interrogating the role of access to safe abortion for those who have been raped. In the JMM case, which is currently under appeal at the Court of Appeal, there are 2 important things that happen in that instance. Number 1, a 5-judge bench declares that when a woman has been raped, it is the duty and opinion of the health professional to assess whether there's a danger to her life. And as such, then the termination may be provided. And number 2, a compensation is given to JMM's mother because this girl, who was 14 years old, had an unsafe abortion, died at the age of 18 due to lack of dialysis, had damaged her kidneys, right? And therefore, we then see the court awarding a sum of about $3,000. I don't know whether I'm doing my math right. 3 million Kenya shillings, which would be 30,000 I will do the math. Somebody will do the maths for me in the chat, right? As compensation for the anguish that the mother of JMM had for those 4 years when they had to treat the consequences of the unsafe abortion, right? Now, there is, however, an unfortunate turn of events as we speak. Currently, we are seeing a rise in an anti-gender movement here that is determined to claw back and take back every single progressive law, policy, guideline that has ever been made on access to safe abortion. I feel it is important for me to highlight this because what we're seeing on the ground for the last perhaps 4 years is an increased demonization of abortion as a healthcare service, right? So we've seen a lot of billboards being erected in Kenya demanding that do not have an abortion, but rather this is a crisis for which you need help for. We have seen protests led by international groups such as Family Watch International, Citizen Go, Human Life International, Heartbeat International, all of them being displayed here in Kenya with the face of those protests being local, right? We've also seen complaints against service providers such as Maristops, where in 2018, Maristops was shut down for an entire month as a result of the demonization of abortion and a complaint being lodged before the medical board saying that they were offering abortion outside of the legal provisions. It is important to note that with or without this demonization and stirring up of the public.
Sorry, Tabitha, wrap up, please. Can you wrap up?
Yes, this is actually my last slide. Abortions have continued to happen. So whether it is in a 35-year-old who is charged for having an abortion at 7 months, whether it is a 24-year-old, this is a 32-year-old, a 16-year-old, unsafe abortions have continued to happen. The last provision and what we are now looking at right now is the most recent amendment to our penal code. And if this is passed, there is a proposed amendment to section 160 of the penal code that then says that it would not be of an offense. If you look at 160A, if the person who offers these abortion services did so while contemplating the provisions of Article 26(4). And therefore, in summary, this is to say that whether or not the law is there, unsafe abortions continue to happen. Prosecution has largely not been successful in Kenya, and it has been a waste of resources. Our judiciary has remained the only viable path that we have, and we do not have a lot of faith in Parliament legislating on reproductive health services. But more importantly to the team that is listening to me, is that there's a deliberate rise of anti-SRH actors who perhaps in the next 10 years might continue litigating more. We might see a reversal of all those gains. We might see an increase in stringent laws. We might also see a challenge of even the Maputo Protocol itself if we're not careful. Thank you for your time and thank you for listening to me.
Thanks very much. Sorry, we do have to keep to time, otherwise we're going to run right into lunch. Any questions? I can see there's John. Actually, do you want to share your question maybe?
Okay.
Let me just close that down.
Maybe all right.
Okay.
All right. So can you hear me? Okay. So I think I was kind of encouraging to hear about the post-abortion care being free and clearly included in the guidelines. So what I was then wondering was whether if a woman elected to abort, whether that was also free, and if not, do you think that in practice limits women's access to safe and legal abortion? Thank you.
I think go ahead and answer that, Tabitha.
All right, thank you. I'll tell you this, John, this was during the beautiful era of everything was bliss. This was in 2013. Unfortunately, with increased taxation, one of the things that county governments have now done is that they have now started charging for health services, including postnatal care, which is now costed at 500 shillings, $5. But that, of course, means a cost has to be paid. So number one, it is no longer free. In any county facility in 2023, 10 years later, unfortunately, it is charged for. You cannot access it for free anymore because county governments have already been making this under their finance acts. Number two, this was only during that 2013, this was only during postnatal care. So you could only access it free if you were going in for postnatal care. And what perhaps we saw in practice is that many women would start the process elsewhere and then go to the public facilities for completion of manual vacuum aspiration or the surgical vacuum aspiration. So this was also something that we perhaps need to go back and do a better study on. But just to insist to you that it's no longer subsidized, it's no longer free. In 2013, Finance Acts of all county governments charge it as part of the healthcare services, unfortunately.
Thanks very much. Fortunately, I don't think there's time for more questions because I am conscious of lunch. But Tabitha, if we had time for a side chat, I'd really want to know what the driving force. You present such a seamless picture, but I'm sure there's really a lot of hard work with reproductive rights lawyers and NGOs and health workers really pushing what's happening. But maybe we can talk about that later in the Q&A. So now we're moving to our third speaker, Crispin Sibanda, who is the Executive Director of the Center for the Advancement of Human Rights and Development. Crispin, over to you. I'll let you know the time.
Okay, so will I use this microphone?
Yeah.
Oh, okay. Oh, okay.
It's a very difficult.
Okay, good morning, everyone. So I was asked to speak on the Southern Africa perspective, and therefore it's not easy to speak on behalf of the whole Southern Africa. I will try. So again, in terms of defining the Southern Africa, yeah.
Hold on. Share it again. Just one word.
Yeah.
I seem to just cancel. Make sure you just. Okay, you can go. Yeah.
Okay. Yeah, so I think defining also Southern Africa is a challenge. And also in terms of when you look at looking at Southern Africa, there's no consensus on what constitutes Southern Africa, but the easier way is to talk about SADC countries that then includes Tanzania, which is part of East Africa. And if you look at the easier way of defining Southern Africa, which is SADC region, you will notice that it consists of 16 countries. That's Angola, Botswana, DRC, Lesotho, Madagascar, Malawi, Mauritius, Mozambique, Namibia, Seychelles, South Africa, Swaziland, Tanzania, Zambia, and Zimbabwe. That makes it easier for everyone, I guess. And then when we talk about Southern Africa and related to women and abortion, we're talking about 390 million people, and women constitute more than half of that population. That's more than 200 million. And this is based on the SADC Gender and Development Monitor 2022. And also looking at the maternal mortality, you notice that the African region, 500 deaths per 100,000 live births. And then the African region accounts for 69% of global maternal deaths. That is the statistics based on 2020. And if you look at the studies that have been done
the major complications which account for 75% of all maternal deaths. There are several reasons, and one of them is unsafe abortion that we are discussing today. When we zero in on issues of maternal mortality in SADC, you will notice that the death related to unsafe abortion contributes significantly to maternal mortality. In Africa, 3.9 million. And then as many as 24% of all pregnancies in Africa end in unsafe abortion. Most SADC countries have considered that the criminalization of abortion is dysfunctional. And the majority of countries in SADC have been very slow in liberalizing abortion law, as I'm going to explain later. And a number of women have been arrested, prosecuted, and jailed based on existing criminal laws in SADC region. And the women and girls know that if they are found to have gone through an abortion, they are likely to be arrested and prosecuted. If we compare in the region, South Africa and Zambia have liberal laws on abortion, and Mozambique is one country that has reformed the abortion law through penal code as late as 2014. As we speak today, 2023, you notice that most of Southern African countries are struggling to reform abortion laws. So if you look at Malawi, for example, there have been civil society movements compared to Mozambique that has led to the drafting of termination of pregnancy bill, and this bill was drafted in 2018. But this is 2023, the bill is yet to be passed in Malawi Parliament. So as we discuss this matter, most of countries in Southern Africa have criminal laws that criminalize abortion and restricts access to safe abortion. So countries with less liberal laws that have less than 5 circumstances under which abortion is permissible, that's Madagascar, which abortion is completely illegal, and then Angola, Democratic Republic of Congo, Tanzania, Malawi, Mauritius, Comoros, and Zimbabwe. Those at least have got one exception or another in the penal code. Then we have countries that have got more liberal laws. That's at least more than 6 circumstances under which abortion is permissible. That's Zambia, Seychelles, Namibia, Eswatini, Botswana, and Lesotho. Countries that don't permit abortion in cases of rape, that's Angola, Madagascar, Malawi, and Tanzania. Then I've got 6 out of 16 countries that don't permit abortion in circumstances of incest. And these are Angola, Comoros, Madagascar, Malawi, Mauritius, and Tanzania. Then some SADC members have national guidelines on providing abortion or post-abortion care under their health systems. So as we discuss, most of abortion laws are under the criminal provisions, whereby you have got provisions that clearly criminalize abortion, and then there are exceptions within the criminal provisions, as I've outlined in the area slides. But then what countries have done is to try to develop national guidelines on abortion and post-abortion care that gives a gleam of hope. Some SADC countries have specific abortion policies that offer guidance on conducting safe abortion and provision of post-abortion care. So 8 SADC country member states, Botswana, Madagascar, Malawi, Mozambique, South Africa, Tanzania, Zambia, and Zimbabwe have abortion and post-abortion national guidelines that have been developed in the past 5 years. So, for example, in South Africa, there is a clear abortion law, but then the country has gone further to develop national guidelines on the provision of the abortion services. And then the same with other countries, that while they have got criminal provisions criminalizing abortion, they have gone further to develop national guidelines. The other point to make is that countries develop national guidelines through the sexual and reproductive health policies. Then the other countries that have come out very clear on developing national
clear guidelines that are specifically on abortion. So because of time, that's why my presentation is sounding general. It's a long paper, but I'm trying to summarize for the sake of time. So all countries except Comoros have some form of policy or guidelines governing safe termination of pregnancy. National guidelines still make it difficult for women and girls to access safe abortion services. So countries with more restrictive abortion laws present with significant higher rates of death from unsafe abortion. Now, despite having the guidelines, because of the criminal provisions that are there, the guidelines itself, the guidelines themselves offer not much more options for women to access safe abortion. So this has an impact on the right to health of women. That's why I'm saying that these countries with restricted abortion rate present significant and highest rates of death from safe abortion. The Guttmacher studies that have been done in a number of countries in SADC have demonstrated that severe restricting access to safe abortion do not reduce abortion rates, but instead they affect the safety and procedure. Women and girls opt for unsafe means of terminating a pregnancy. As I've highlighted, the existence of the criminal provisions, the national guidelines that still do not offer so many options to the women, and then women and girls opt for unsafe means of terminating pregnancy. So countries with very restricted abortion laws, such as Madagascar, Malawi, Comoros, Angola, and Tanzania, have high proportion of unsafe abortion and deaths of women as a result of those unsafe abortions. Then even in countries where the law permits abortion on broad grounds, procedure barriers such as compulsory waiting periods, authorization, consent requirements, restrictions on abortion providers and facilities, or mandatory medical authorizations may prevent and undermine the access to safe abortion services. And in the paper, I've given examples in terms of how each country in SADC have developed their national guidelines and how some of these barriers have limited women from accessing safe abortion services. So the question you may ask that in terms of your presentation, there seem to be very little hope for women. So the hope comes in that we have got other countries in SADC that have gone further to reform the abortion laws, countries like South Africa, Zambia, and then Mozambique. But also, these countries that I've talked about, which are 16, they have got a common grouping that is called the Southern Africa Development Community. And this grouping develops declarations and protocols on different matters of politics, trade, and then in terms of health. So in terms of health, these 16 countries over the years, they've been doing a lot. They've developed the protocol on health, they've developed a protocol on gender and development, and now they have a sexual and reproductive health rights strategy, which is for 2019 to 2030. Now, when you examine the strategy, the outcome 5 of that strategy says that these countries should reduce unsafe abortion and teenage pregnancies. Again, when we focus on the protocol on health, Article 16B of SADC Protocol on Health says that countries have an obligation to formulate policies and programs on reproductive health with an aim of reducing maternal mortality. When we go to the SADC Protocol on Gender Development, you will notice that under Article 26, that countries should adopt policies and policy frameworks to address sexual and reproductive health needs of women and men, including reducing maternal mortality by 75%. And we know that reducing maternal mortality needs the addressing the access to safe abortion, which is a great barrier to SADC countries.
Again, in terms of opportunities that exist, so SADC countries have signed and ratified the African Charter on Human and People's Rights, and the Article 16 provides for that to have. And then these SADC countries have all, except Botswana and Madagascar, have all signed and ratified the African Protocol on women's rights. And the Article 14 says that the parties to ensure that the right to health of women includes sexual and reproductive health. And in fact, being specific under Article 14 2C, which is familiar especially for a grouping like this one under Ngwena, that the countries should take all appropriate measures to protect the reproductive rights of women by authorizing medical abortion in cases of sexual assault, rape, incest, and where the condition of pregnancy endangers the mental and physical health of women. Now, further to that, there have been a general comment developed under Article 14, and this guides countries that they should take measures to stop the prosecution of women because of issues of abortion, which is a major problem in SADC countries that can also be defined as Southern African countries. And also going global, the SADC countries, all of them have signed and ratified the International Covenant on Economic and Social and Cultural Rights. And Article 12 provides for right to everyone to the enjoyment of the highest attainable standard of physical and mental health. And in fact, in the paper, I've even highlighted the general comments that have been developed under Article 12. And also, SADC countries have signed and ratified CEDAW. If you look at the exceptions, if you look at countries that are yet to ratify CEDAW, you find that these SADC countries are not among them. That also offers hope and opportunity to SADC countries, and also especially the guidelines that follow through the general comments. And almost all these SADC countries have got domestic constitutions that includes Bill of Rights. And in a number of them, as I've highlighted in the paper, it also includes issues of women's rights. These SADC countries have also been making progress in improving the lives of women by adopting laws and policies on gender equality that includes access to sexual and reproductive rights. In the paper, I've highlighted the countries that have developed specific laws on gender equality, that includes parliamentary legislation on gender equality. And those pieces of law, you notice that they include issues of sexual and reproductive rights, and therefore, sexual and reproductive rights include issues of access to safe abortion, which is also a very big opportunity for SADC countries. Now, another opportunity that exists is litigation. So in my paper, I've highlighted what has gone elsewhere, but for Malawi, there's a current case that has just started. I think this is in November. I think the case was filed in September this year. The case is being led by Center for Reproductive Rights with support of local NGOs in Malawi. The newspaper caption I have highlighted here, it's from a local language in Malawi. To me, it gives hope and opportunity, because it means the journalists are communicating locally that this case concerning a 14. The 14 you see there, it's an age of a girl that was denied access to abortion by a medical facility. So some civil society organizations with support from Center for Reproductive Rights, and I think from the spearheading by local NGOs, have filed a case with the High Court. And this case is focusing on the interpretation of the exception in the Penal Code on that a woman can be allowed to terminate pregnancy under the Penal Code, where there are no guidelines. So what the civil society are trying to do is to see, with the submissions from them and the friends of the courts, to see if the courts in Malawi can expand the exception in the penal code to make sure that women can access safe abortion. And the case of a 14-year-old girl is being used. So it's a current case that has just started, and there is a lot that needs to be done for the case to be done. But I see that it's an opportunity that exists. Again, the opportunity, if there have been civil society-led abortion law reform movements through parliamentary process. So one example I've already given, that it was successful in Mozambique, where the penal code was amended to expand abortion services. For Malawi, what the civil society have been able to achieve is to have the bill drafted. But as we discussed, the bill is yet to be passed in Parliament. And then also, I'm proceeding to talk about challenges. So one of the challenges, which is also an opportunity, as I've highlighted in the areas slides, that with the partnership of civil society, now there is a case in court, for example, in Malawi and in Mozambique. There was success whereby the civil society partnership led to the liberalization of abortion in Mozambique through Parliament. But also this partnership poses also challenges because it's not easy to work together as civil society organizations. I know that in Malawi there have been a lot of debate whether to litigate or simply focus on parliamentary process. Another challenge that exists in SADC countries is the adopting the international and regional human rights mechanisms, like, for example, the SADC tribunal. How can it be the judgments from SADC tribunal? We are yet to see any from them on abortion, but if it comes, how will the countries adopt it locally? And then the several progressive pronouncements from the African Commission on Human Rights, we are yet to see those fruits at local level, but also the pronouncements from UN Committee Special Rapporteurs, the special, the Universal Periodic Review, general comments, the different strategies that exist at international declarations, protocols. You find that these are yet to be adopted at local level in SADC region. Right now, there's also a lot of debate on funding from donors. There's also a need for more research because the data from institutions like Guttmacher, research done by Center for Human Rights at University of Pretoria, have helped a lot to shape some of the discussions at local level. Therefore, we need to see how these can be furthered, especially that some countries need specific research, but also specific advocacy. There's also issues of politics, whereby politicians shun away to champion issues of self-abortion because they're afraid that they may lose votes. But also, I've highlighted in the paper, in most SADC countries, the opposition is very real. And you may also, I think, I've noted from my area, from the area presentation from Kenya, that opposition, they even erect billboards. So this also poses a challenge in terms of offering opportunities, but also the significance of accessing safe abortion services in SADC region. Because of time, I think I can stop here. Thank you.
So much. Thank you. I mean, I think that was a masterly overview of an entire region. And what was really useful was to look at the different ways in which countries are finding their way, whether it's through courts or through parliaments or through drawing on international frameworks. And of course, ending with, I suppose, what people go really worry about, which is the rise of opposition. Actually, I think opposition's always been there, but it does seem to have become a lot more visible in the last few years. Any questions on the SADC region? There's a couple of comments online, but no particular questions. So can I just, maybe I can just ask a quick question. So is it, if we thought about countries with progressive abortion laws in the SADC region, would it just be Mozambique and South Africa at the moment?
So it's not just Mozambique and South Africa, but also Zambia.
Zambia.
Yeah. So Zambia has had the termination of pregnancy law for a long time. But when you look at the guidelines and also the law, it offers a lot of barriers.
Okay.
I know that there have been efforts by civil society organizations in Zambia to see how they can improve. But there's also been a worry that with the presence of opposition, if we now talk a lot, you may lose. With
You may be pushed even further back.
Yes, I know that was also posed the challenge.
Yeah. Okay. Thank you. I mean, that is a worry. You know, in South Africa, when democracy started, people really thought about going to the court to actually push abortion rights in South Africa. And I was one of a group who actually went and stopped cases from being prosecuted because we thought the courts were the worst place at that point in time. We thought Parliament was the best way to go. And it was, but it's a difficult choice to make. You've got to read your courts really carefully, and you've got to read your Parliament, and you've got to think about where you can get the best outcomes, if any. So I think we do have to move on. Thank you very much for that.
And I tried to keep time.
You did it extremely well. Thank you very much. I'm sorry, I am being a little bit of a fact when it comes to that, but we are constrained. So our fourth speaker now is our fourth speaker, Dr. John Ngwena, who is from the University of Ghana, the Department of Population, Family and Reproductive Health, and their School of Public Health, and he'll talk to us about West Africa. So over to you. Okay. Just sharing screen.
Yeah.
Do you want?
I don't know if you Rachel, if they can hear me.
We'll just move it over as far as we can.
Yeah.
Which is not very far. And maybe it's there.
Maybe let's look at also back.
Okay. No.
Are you logged into this meeting?
Yeah.
Right.
There.
Okay. Can unmute yourself? I can block this one.
I cannot unmute myself. Okay. All right. Okay. Should I try? Oh, this one.
You see it from here.
Yeah. Okay. Oh, sure. Oh, from this one. All right. Thank you. So I'm going to be talking a little bit about West Africa, and of course, like some of our previous colleagues have observed, it's a really vast but also complex environment made up of a lot of Francophone countries, but also Anglophone West Africa. So I'm from Ghana, so I'm going to be giving a lot more detail also from Ghana as well. So I'd like to start from a point of unintended pregnancies, and I've just given that for a couple of the countries in West Africa. Of course, because a lot of the abortions and unsafe abortions that we have are essentially product of people not wanting pregnancies, but they have happened. And so if you look at this rate, per 1,000 pregnancies, you see variation across the region. Of course, population is a factor, but you also see places where the numbers are not that high, but you really have high numbers of unintended pregnancies. Of course, Nigeria, Ghana, Cote d'Ivoire, Okay. And Senegal, Burkina Faso, all of them having quite a lot of pregnancies, some getting closer to half of 1,000 being unplanned. And of course, once you have that, that feeds into not just unsafe abortion, but also maternal mortality. And I've just highlighted the West African region, the countries that are data available that were captured, comparing 2017, 2020. And I think one of you would see a number of countries actually increasing in terms of maternal mortality, but they've also been very significant declines, especially in a country like Sierra Leone that had, I mean, before, if you think about 2017, was well over 1,000 and maternal mortalities, 100,000 births, have really done a lot of work to reduce this to a little over 400. So it's a mixed bag of progress and all of that. And like the previous speaker shared, there are multiple causes, but I think for our interest is the cause that's related to abortion. And across the continent, it's about 7.2%. But of course, there's variation and all of that. And also, there's some research that suggests that this typically is based on data that comes into health facilities. So the possibility of underestimation is very high. Now, if you then look at country-specific data, you will see a range, again, you see a range of performance in terms of the contribution of unsafe abortion to maternal mortality in these countries. So I think if you look at it, Senegal probably doing 10%, but of course I have to say these are usually very conservative estimates. In our own country, Ghana, for example, there are some studies that have suggested between 12 and 15%, and in some facilities it can go up to about 30%. So these are regional level data, but there are variability across the region. Essentially, what you see is that every country in the region has a good number or proportion of mortality from maternal mortality from unsafe abortion in the system. And of course, these are, like previous speakers have said, is related largely to the nature of abortion laws that we've got in the region. Most of them actually have colonial background, whether it's a French colonial policy or is the British colonial legislation that essentially prohibits abortion in many of these countries. And of course, what that means is that it often leads to harassment or prosecution, or in some cases, some have called it persecution. But it also then generates a lot of stigma, because then when you combine that with all the religious activism and social activism, then stigma is there. And then you have on top people very unwilling to provide, because then you are likely to be arrested or you get stigmatized. And of course, that feeds into the whole National Health Service, in which case, limited provision. So there are a wide range of these drivers across the region. What is the status of the different countries? So this is actually based on 2020-2021 data, but I think quite a number of changes have happened that try to kind of classify countries along a continuum of legal status. I think at the moment, the places that we still really have limited grounds for requesting would be around Senegal, Sierra Leone, and then Mauritania. The rest of the countries do have some space for requesting abortion under different circumstances. In fact, some countries have many circumstances, and women can request. So, but I like to, for example, highlight a country like Benin. That is probably the most recent example of really progressive abortion legislation that not only focuses on the woman's physical or mental health, but also include a wide range of socioeconomic reasons, such as professional development or education in that regard. Of course, there are a few that there are currently no clear restrictions. Of course, there's a gestational requirement. For example, below 12 weeks is typically okay, and then after that, there's some requirement in terms of who can perform that service. So, in a general sense, there's a broad range of legislative space for women to seek abortion in the region, and of course, you think about it, recently we started to discuss a lot of medication abortion. There's some data that suggests that some countries have even gone ahead to include, for example, some of the main medicines, misoprostol, for example, in their essential list. And like I mentioned, Benin, after passing its rather very liberalized abortion law, actually included all of these different combinations. Ghana is done same, really one of the progressive places, but you have different kinds of permutations in terms of countries that have these in their list. Of course, this 2019 data for most countries, so I expect that there may be some changes in some of the places. All right, so and I think this is important because it gives women some room to actually then initiate the process themselves. And of course, the WHO and other organizations are talking more about self-care now. So these are really important commodities in terms of access to abortion care. I think this is I was hoping to get a West Africa more specific one, but I didn't get that. Essentially, what I wanted to show here is that the progress that has been made. So if you focus on the West Africa region, we've seen a bit of shrinking of some of the more restrictive regimes to a little bit more flexible and more open kind of abortion policy regimes over the last 20-30 years. And that is good progress, even though very slow. And in the literature, there are a lot of discussions about why we've had this. Of course, human rights and related commitments are part of the conversation. A lot of these countries have either signed onto or ratified, for example, CEDAW and the Reproductive Protocol in particular. And these countries have also individually, a lot of them promoting gender equity, equality policies. For example, Ghana has done that since 2015. And so these have specific recommendations in terms of making sure that abortion services are made available and are seen as human rights, services that need to be provided. Of course, beyond that, a lot of what we've seen, and I think the language across the region is a bit of focus on maternal and child health. And we know the MDGs, SDGs have really driven this very, very well. So a lot of countries are incorporating comprehensive abortion services under maternal mortality because it's an important contributory factor. Of course, universal healthcare is come and is becoming one of the ways to think about expanding access using a human rights-based approach. The agenda 2063 has also become an important point for expanding access. But of course, I have to say, civil society has been played a big role in causing some of these shifts. And for example, IPOS, and I believe Polly will talk about that more, has played such an active role in Ghana in terms of getting the abortion legislation interpreted in a very broad way, but also engaging a whole lot of stakeholders to try and draw attention to the need to actually make services more available. And in other countries, including Benin that I've cited as an example, there is real active civil society groups that worked very hard to make sure that the law was passed. Of course, there are, like I said, examples, and I think in the region, apart from the Benin coming quite recently, Ghana has been a very good example of that. Of course, the law itself is not that very liberal, even though there are several grounds. But what it's done is to take a very broad approach to interpreting the law, and this was made possible like sometime in 2016 when about 5 international organizations came together and they formed what they call the affirming Consortium, Reducing Maternal Mortality and Morbidity Program, that essentially was trying to reduce maternal mortality through the reduction of unsafe abortion. And this was done in some regions of the country at the time, essentially making sure that they are engaging with leadership to set up systems that would provide abortion services. Of course, up until this point, post-abortion care, for example, was what was done. That's not illegal. It was treated as a medical emergency that required urgent care, and so that was taken care of as part of the regular services. But really, elective abortion or women going in wasn't something that was common, even though in the law there are a number of circumstances. So essentially, AFRIM took it to a different level by kind of engaging with key stakeholders to develop a different approach to the law, and by developing and revising service protocols that would actually make it possible for the services to be provided. And I think this went on for more than 10 years. There are different kinds of evaluative reports that have suggested very good progress. Sometime in 2020, that consortium kind of ended, but the Ghana Health Service itself got the funder to continue to support the program, which is now being done nationwide, and they call it institutionalizing comprehensive abortion care. And it's basically run on 7 pillars, which is developing leadership and teams at all levels of the healthcare system for abortion. So you go to the region and there's a regional CAP team, you go to the district and there's a district CAP team, and then you go to a district and there's a district CAP team. And so basically making sure that whoever leads the service understands that abortion is a service that needs to be provided, just as you would provide malaria services. Service delivery is one of the legs, and they are training a lot of staff, of course, linked to workforce development, and especially expanding the personnel, the category of personnel who can provide. I think as previous colleagues have talked about, the debate around who could actually provide this service. Until now, or until then, the understanding has always been a medical practitioner, and that means a doctor. what the policy revisions have done is actually to expand this and say, well, midwives can actually provide the services, of course, with certain limitations on gestation and all of that. But essentially, it's expanded the list of people who can provide the services. And so it's entirely possible in some of the facilities that have undergone training to find a midwife providing services in those places. And then an important aspect is also what they call the data capture. So there's an entire system that has been developed to not only capture the type of services that are provided, but also monitoring what commodities are coming in and how they are being used and all of that. And financing, and that's an interesting part because historically the Ghana Health Service, for example, would not include budgeting for tax services as part of its regular budget. Now there's a requirement to do budgeting at all levels of the healthcare system. Of course, funding is still an issue, as I will talk about in a second, but that's becoming something that is happening. And then the final leg is what's like advocacy. And so there's still a lot of work with community champions and other stakeholders, including the police force, law enforcement, and the judiciary to essentially explain that we haven't really had any serious cases of prosecution that much in Ghana. And I think that the court system hasn't been really used that much, even though police have often intimidated service providers. Yeah. So that's what is happening now and becoming hopefully a model that can be used. But of course, like others have highlighted, we still have the issues of abortion not being fully legal in the region. And so that leads to all the other consequences about harassing prosecution, and then the availability of services being limited. And then, of course, post-commodity supplies. For example, Ghana is the big thing. You can get a service for 200 cedis, and you can get it at another place 800 cedis. So there's a real issue in terms of that. And of course, recently there's also conversation around what the global development, like the ruling in the US, would mean for funding in particular, because then there's a pullback on traditionally, for example, USAID that would fund some aspect of this, pulling back on that. I think the last bit is just thinking about areas that these regions have to focus on. Of course, new legislations, but what has happened in Ghana, for example, would suggest that maybe what we actually need is like interpreting the law in a very proactive manner and making sure that it's the different circumstances are utilized, but also making human rights central in the process, and also information dissemination. Some of the studies that have come out suggest that even where there's legalization, sometimes women don't know that this has happened and they can access it. And I think it will be important to do that. So I think I would end here and then we can go with discussions. Right.
Thank you.
Thank you.
Thanks, Dirk. Which mic should I use?
I can hear you from here.
Yeah, so I can just talk. Great. Okay. Thank you. That again, a fascinating presentation. There's a question in the chat from Munyaradzi Tsunga, who asks about the different strategies that countries have managed to use to legalize abortion.
Right.
And as a lawyer, I always think about law reform and litigation. But what's coming out in a lot of these presentations is really health worker, health services led reform, regardless of the law.
Yeah.
And I know that's happened in countries in South and Central America as well. So that was a really interesting intervention. I mean, I think Kenya is also partly an example of that, and also just fascinating the county-led health bill revisions in a place like Kenya. Are there any specific questions for Ghana, for West Africa?
So that question, I'm not sure whether it was for.
There's a comment on the chat
South
around
Sudan
strategies, and I think
it touched on some, but I can also respond.
Maybe
a bit.
respond to
Yeah.
that.
So I think like you said, different strike. I think in West Africa, I think the legal route hasn't been that much used effectively, but we've had a lot of the health, and also there's a bit of personal influence. So you look at the Benin example, and the minister and some MPs who both had a gynecology background basically were the people leading this, and they led it from a health perspective, right? And saying we've got to do something about this. This is an important health issue. And then you get buy-in of people within the lawmaking group to do that. There's a very interesting story about Ghana as well. So 2010 thereabout, we were going through a constitutional review process. It hasn't materialized, but I think at the time too, there was this whole fear that if we were to go through this, then we would have people saying, let's just remove all the conditions that women can use. And so immediately, I think then IPAS and then the Atrium Consortium essentially formed a lobbying group that then went into Parliament, and essentially like all of those who were in the Health Committee of Parliament, for example, started to engage them. And essentially, so it was like, no, this is not something that we are even going to move, but we would just make sure that it is left with the Ghana Health Service to interpret. So I think parliamentary lawmaking has been very important, but also like people who are very passionate and come from a health background in the region have also been very strong about this. Maybe what I didn't talk about is yet there are probably pockets of opposition as well, but these are often very soft. So in Ghana, we don't see this outward kind of like protest or visible sign that people are opposed. Of course, in some religious circles, people would be like, no, you don't even go there. But it's not that visible, and we in the last few years we haven't heard anything like that. Yeah.
That's great. That's fascinating. And actually, it's a wonderful segue into our last speaker, who is from IPAS in Francophone Africa. So Dr. Bilkisu Balda, who's the regional director of our IPAS in Francophone Africa, is going to speak next. I was just asked you to pass my 2 minutes. So,
yes, sure.
Yeah. So I think that
You just stop sharing, right?
Yeah, please go ahead.
So you just stop sharing.
Yeah.
You share.
Yeah. Thank you so much again for having me on this panel. So I will be talking about sharing on the Francophone perspective on breaking barriers to safe abortion access. And some of the things that I'm going to say overlap with some of my, the previous speakers, because Francophone being basically French-speaking countries are spread out to the African region. So however, we wanted to make sure that we really put the focus on Francophone, because most of the Francophone countries have laws that criminalize abortion or that are highly restrictive, impeding access to safe abortion for women and girls. So I'm going to talk about unsafe abortion rate in the region, also the multiple barriers to safe abortion access, the change related to the regulatory framework, including the progress that we have made in the past 2 decades. And then I will just share a little bit more on some of the local action and strategies to kind of help change the laws. And then I will be sharing a few thoughts on the way forward. So before I dive into tackling the barriers to safe abortion access in Francophone Africa, I would like to draw your attention to the increasing scale of maternal death due to unsafe abortion. According to WHO, the Guttmacher Institute, 42% of yearly deaths worldwide are related to unsafe abortion. The sad reality is that unsafe abortion is one of the 3 leading causes of maternal death globally. And it is an overwhelming loss of life. And behind each of these numbers lie a personal tragedy, the story of a woman and a girl who did not receive the care and support they needed to access safe abortion care. So I think it's safe to say at this stage that unsafe abortion has become a global health crisis. So in the sub-Saharan Africa, the statistic of on unsafe abortion are even more alarming. While the abortion rate in the past decade seems steady because of population growth in the region, the numbers of abortion annually have doubled, claiming the life of far too many women and girls. In addition to unsafe abortion being the third cause of maternal death and morbidity, the WHO estimates that 3 out of 4 abortions in Francophone Africa are unsafe. As you can see on your right, on this slide, West and Middle African countries, which are also part of the Francophone region, have higher proportion of less and least safe abortion compared to the Eastern and Southern African countries. The impact of unsafe abortion goes beyond the loss of life, and it's really perpetuates the cycle of inequality and injustice. And we cannot simply turn a blind eye to this reality. I want to talk a little bit more about the barriers that we are seeing, the ones that are preventing access to safe abortion in the region, which are, by the way, far-reaching and contributing to the high rate of unsafe abortion that I mentioned previously. And one of the primary barriers to safe abortion access is the presence of restrictive laws and policies. Many Francophone countries, like I previously mentioned, have laws and policies that criminalize or severely limit access to abortion, forcing women and girls into the shadows. And where progressive laws exist, there is an ineffective implementation simply because of judicial interpretation or simply due to a lack of awareness of abortion laws by both providers and the people seeking abortion care. Another big barriers are societal stigma and discrimination surrounding abortion, which act as a significant barrier for access. So the cultural and social norm within the Francophone African countries often contribute to the stigma, leading to judgment, shame, the isolation of women, and preventing them from seeking the care that they desperately need. Another significant barrier is the inadequate availability and quality of abortion services. Many healthcare facilities in the region, as you all know, lack the necessary infrastructure, equipment, and trained healthcare professionals to provide abortion services. So this leads to delay and unsafe practices, increasing as well the health risk for women seeking abortion care. And in many university and medical training institutions, I'm sad to say that abortion care is still not part of the formal training curriculum. A related barrier to access to safe abortion services is also the consensus objection of healthcare providers, leading to refusal of care due to moral or religious belief. The lack of knowledge and information regarding abortion services and the regulation, like previous speakers have shared, is also a barrier that is actually often neglected, and we don't realize how much providing accurate information is critical. Many women are either unaware of the rights, reproductive rights, or the available option for safe abortion care. Actually, a recent study by WHO showed that healthcare providers also lack the necessary knowledge and up-to-date information on the regulatory framework or even the comprehensive abortion methods available in their own countries. So many women as well, particularly those from marginalized community or low-income backgrounds, struggle to afford the high cost of safe abortion. So these financial constraints lead them to seek unsafe alternatives that sometimes are even more expensive than the safe abortion care. Another growing barriers that I was glad to hear a lot of the predecessors mention it is really the growing the opposition from anti-right movements. So SRHR and abortion right defenders are being increasingly attacked by anti-right actors, particularly in the Francophone Africa region. So this opposition has been there for a very long time, but it was silent and more confined to some specific context. Now we see the attacks growing, adapting, and moving from the previous silent state to fueling disinformation on a bigger scale, and even influencing public opinion, shaping laws and policies. So while the list of barriers is long, as you can see, and certainly not exhaustive, our decade of working in the Francophone Africa region has really taught us that one of the key contributing factors to the prevalence of unsafe abortion is restrictive laws surrounding abortion. And one interesting learning as well, I would say, is that really changing the penal code, it's more challenging than actually updating, I would say, the standard and guideline that you previously mentioned. Although one must recognize it's not sustainable just to update the standard and guideline, but I guess it's faster because at the end of the day, women are dying while we are debating about whether abortion is legal or not. It is important as well to recognize that restrictive abortion laws do not eliminate abortion, but push women, like I said, into seeking unsafe abortion care. And women who are desperate to terminate pregnancy will seek out dangerous methods, often performed either by entering individual or in non-hygienic environments. In reality, when abortion laws are restricted, it does not reduce the number of abortions. On the contrary, it just increases the number of unsafe abortions, which further endanger like women's lives, their well-being, and their reproductive autonomy. So despite the ongoing struggle for access to safe and legal abortion, it is essential, I think, to acknowledge that in the past 2 decades, we have made some progress, at least in the Francophone Africa region. So human rights authorities state that the criminalization of abortion violates women's right to health. So this is an interpretation of multiple international treaties ratified in by many of the Francophone African countries, such as the CEDAW in its Article 12.1 and I think 12.2 as well, the International Covenant on Economic, Social, and Cultural Rights, the Maputo Protocol that many of you have mentioned here. So from a human rights standpoint, legal and regulatory barriers that impede women access to safe abortion care should be eliminated. So we can see, apologies, going too fast. So we can see on this slide as well, in 2021, more countries have moved toward easing the legal restriction to safe abortion compared to 1994. So some of the legal changes in the past decade include fewer countries which are prohibiting abortion altogether, and more that has allowed abortion to save women's lives or to preserve their health. There is also the addition of provision related to both social and economic grounds for safe abortion access. And abortion is actually available upon request in some of these countries, depending on the gestational limit. So abortion care is legally, like I said, restricted in many Francophone countries, although many of them have adopted and ratified the Maputo Protocol. So while challenges in realizing access to abortion care persist, we are seeing increasing political will, and there have been as well notable advancements that I think deserve recognition. So in the recent year, for instance, legal reform have been enacted to extend access to safe abortion in several countries, such as Benin, where previously abortion was legal only to save pregnant women's lives and in case of rape or incest. So in 2021, it is now legal up to 12 weeks of gestational age, and in case where the pregnancy is likely to worsen or cause a situation of material, education, professional, or moral distress, which is incompatible with the woman's interest. In DRC as well, in the Democratic Republic of Congo, where they have also fully ratified and domesticated the Maputo Protocol. So the publication of the Maputo Protocol in the official journal that have helped make Article 14 the reference for legal interpretation for access to safe abortion care instead of the penal code, as I was mentioning. So they have also updated the national standard and guideline, which has allowed for the access to safe abortion in the Congo. One is another example where they have increased the legal grounds for safe abortion access, which at the defense of other countries, like you can see on this slide, such as Cote d'Ivoire and Burkina, they are taking concrete steps to ease access to safe abortion. So overall, in the Francophone Africa region, the changes in the legal framework have extended the gestational limit or added more ground for access to safe abortion, such as mental and physical health, economic and social reasons. So several countries as well, such as Ivory Coast and Mali, are currently reviewing the SRHR laws, and many others have shown an increased political will in favor of less restrictive laws for safe abortion access. So this significant legal change has paved the way to greater reproductive autonomy and access to safe abortion care for women in Francophone Africa. It has also been provided a framework that acknowledges the importance of protecting the health and the right of people who are seeking abortion care. And we are hoping that it will inspire other countries such as Senegal and Madagascar, where reform is stalled because of the lack of political will, or simply the refusal to recognize that unsafe abortion is one of the leading causes, like I said, of maternal mortality and morbidity in these countries. Also, as we celebrate the 20th anniversary of the Maputo Protocol this year, and we look back at the progress that we have made in the last 2 decades, I would say, partners from the safe abortion movement in Francophone Africa have made some few key statements that I would like to share with you all. So for the African Commission on Human and People Rights to simplify and multiply the Commission channel for dialogue and feedback, to also have a more inclusive process that enables the Commission and state to work closely with feminists and other civil society organizations and actively include them in the decision-making, in policy implementation, and monitoring to strengthen accountability mechanisms. So to donors as well, to support robust initiatives that allow or involve flexible and sustainable funding to help them reaffirm like the place of safe abortion in the collective vision and also definition of SRHR in the region. So it is often assumed that because the law legalizing abortion has been passed, people will have access to safe abortion. So while enabling a legal environment, addressing the barriers to safe abortion access require sustained collaboration and commitment from government, civil society, healthcare providers, activists, and other partners at all of the intersection of safe abortion right and access. So at IUPAS, we use the sustainable abortion ecosystem that I wanted to share with you, responding to the previous question about how we go in different countries supporting legal changes. So the IPAS Sustainable Abortion Ecosystem Model is a framework, a set of tools and strategic planning process that help advance sustainability through partnership by responding to local opportunities where we work. So basically, we use this framework as a dialogue tool with a wide range of partners to co-identify and agree on what we see as the most important and pressing opportunities, gaps, and threats across the 8 programming components that you see on the left on this slide in the petal of the flowers. So these are components that need to be addressed to advance sustainability. So the 4 drivers that you see on the outside on your left, which are how we go about conducting the work to create sustainable outcome. So the sustainable abortion ecosystem model works because it centers our work on the need of people who seek abortion care. It also builds upon the intersectional areas of abortion related to food SRHR issues, not only unsafe abortion. So the people who need abortion and contraception have intersectional needs, as we all know, that must be addressed to truly create like a change that supports them. So our approach at IPAS addresses unsafe abortion not only as a single issue, like I mentioned, but as a part of a broader reproductive and social justice issue. When I was introducing myself, I also mentioned that currently at the IPAS Francophone Regional Office, we are incubating a regional organization that is called ODAS, which is Organisation pour le dialogue pour l'avortement sécurisé. Like I was mentioning, it is the first regional mechanism that is entirely dedicated to strengthening the safe abortion movement in the region. So you can see ODAS as the beating heart of the youth and feminist pro-choice movement in Francophone Africa. So we have been working closely through ODAS with a lot of other partners in the Francophone region, where we have come to realize that civil society, particularly the youth and feminist movement, are key to securing and advancing access to reproductive freedom and safe abortion access in these countries. So feminist and youth organizations, like you all know, are at the forefront of the defense of human rights, and they play a decisive role in combating the stereotype, discrimination, and gender inequality that stand in the way of reproductive freedom and safe abortion access. So we see really this as a way forward to move to safe abortion access beyond the realm of healthcare through reproductive justice. So before concluding my presentation, given that I'm the last speaker here, I would really like to leave you with these basic facts about abortion that I believe everyone should know, which are people have abortion all the time, regardless of what the laws say. And almost every death and injury from unsafe abortion are preventable. Access to safe abortion is a matter of human rights, and many countries, at least in the Francophone Africa region, have started to change the law to allow for greater access to safe abortion. And the most important of all is that criminalizing abortion to not stop abortion is just make them less safe. So if you're asking yourself, what can I do? And then my suggestion would be change your mind by learning more about safe abortion without bias. You can also start asking yourself and others the right question, particularly on the need or benefit, if any, for the legal restriction on safe abortion or reproductive autonomy in general. You can also stand tall to support access to safe abortion, safe and legal abortion like I do. Once again, thank you for having me.
Thank you. Thank you very much. That's lovely and very nice actually to end on an activist note. So we have 5 minutes. Are there any questions? I think if there aren't any questions, I'm just going to give maybe the panelists an opportunity each to make one comment, and maybe just speaking to the very last comment on the chat from Murazi, who is in South Sudan, who talks around the real sort of deprivation of abortion access and healthcare services and the highest maternal mortality rate in the world in that country. And I think if you were to extract one piece of advice from your experience, I don't think we're going to be able to ask Irene because I think she's gone. But if you were to extract one piece of advice for your experience as to what works in terms of beginning to break down those terrible barriers for women's access to safe abortion, for a country that is really, I think, grappling with that. Maybe you can all end on that note. So I think, Tabitha, you'll probably be the first one to go on that, please. And just keep your comments to 1 to 2 minutes max.
All right, there. I hope I haven't muted myself and you can hear me. I am going to try and keep this just to, the question that was asked. I would say 2 things. Number one, learn to appreciate small but incremental gains. And this is our experience in Kenya, where we started with a very stringent 1963 pure decriminalization, and then incrementally built on that to say, beyond saving the physical life of the mother, let's go to the health of the mother. Let's go to emergency services. Let's go to rape. Let's go to fetal abnormality. And eventually our hope is that we're going to challenge this, sections 158 to 160 in court and decriminalize fully. But I would say small but incremental gains where you start with 1, 2, 3. From our colleagues in Latin America, the advice that I have been given is that you also need, beyond the court processes and challenging some of these things in court, it's also the court of public opinion. That sometimes when a community is rallied up and they're fed up with the number of deaths that are happening, you could see what we saw with the Arab Spring, where you see that incrementally for them, they've just been fed up. The Green Wave movement, for those who are looking for inspiration, for our colleague in South Sudan, has done so much work, whether it's from Colombia to Argentina. And I would say, if that works, the situation and environment should be able to tell you whether to take the incremental approach where you use the courts or parliament just for one step at a time, building blocks, or alternatively, start feeding and activating the community. Let the ground demand for this type of injustice to end for women.
Thank you. That was wonderful. Next.
Yeah, I think it is important to learn and study the local context. Advocating for safe abortion goes also with the local context. You find that in certain countries, you may need more voice from medical practitioners who raise the subject from technical point of view. Gynecologists and nurses talking about the problems that they face in terms of service delivery for women. You may also find that in certain countries, you may need the voice of religious leaders. While the religious leaders are portrayed in the category of opposition, but there exist some individuals within the religious sector who believe in safe abortion and may be good advocates. In certain countries, you may also have the voice of chiefs and traditional leaders, depending on that country, that they may be very influential in terms of the discussions and also changing the environment. In other countries, the civil society may be key in engaging different stakeholders, while comparably in other countries, the moment you use civil society, it becomes a barrier, because in certain governments don't want to listen to civil society. Also, politicians, you find that you have members of parliament that are very supportive on issues of abortion. You may want to utilize that. So for me, it's a matter of trying to understand the local context, because the countries differ based on the kind of the politics, the environment, the history that exists. You may find that the story in South Africa is not the same as in other countries, because South Africa has got a unique history that contributed to having liberalized abortion laws. So it's for me, it's very important to understand the local context, but also learn from others. You may learn what happened in South Africa, you may learn what happened in Zambia and Mozambique, and also other countries. Look at the abortion map in Africa. It's not the same. So the lessons from one country can be imported or exported to another country. That will be my context.
Thank you. Thank you. Dr. John.
So I think what we've also learned is in addition to all that has been said, is the legalization, all of that is absolutely important. But actually, you do yourself a lot of good spending time to communicate, both in terms of the law, but also communicating with people. So in one of our engagement with a regional health director, I said, well, I went into a new region that had really high maternal mortality, and part of it was abortion. And of course, he said his strategy was this. He went to the paramount chief, that's like a really authoritative figure, and said, look, Nana, last year, 4 buses, so we have there's a common bus like OA bus, 4 red OA buses loaded with women who were pregnant just disappeared. And I was like, what did you say? 4 OA buses? How? In this region? And that really just worked magic, because then the chief could immediately relate to the numbers. This is the size of the bus, and it's just outrageous that this number just went missing. We didn't find them with the bus. And so the way you communicate and engage people could make a whole lot of difference. And I think in Ghana, that has been an important part of it. Of course, the other part is like getting people within the service. And I think Ghana, that has been one of the drivers, that if you have the leadership in the service say, this is a health service, we would provide it, then it becomes then easier to start to engage the other stakeholders. But once you have resistance within, you can make it fully legal, but if people are resisting because of their values and conscientious objection, and you don't have providers, you're not going to make headway. So I think making sure that you have people within the service that support it is an important approach.
Yeah. First off with this on side. Dr. Lucas.
Yes, thank you. I think I will agree with the previous speaker here that know your context, know your audience. There is no like one size fits all solution about how to go for access to safe abortion in different countries. The case in South Sudan is different from the case in Mali, although it's the same region. I will also say that it's important how we communicate and that we should be intentional about really identifying the voices that are missing around that table. We need all of the voices. And so think really big, inclusive, what are missing. And also, like I was saying, we need to find allies, whether it's within the country, whether it is outside, extremely important. Because like one of the speakers said, it takes time. It's a really long journey and you need to hold on to the small game that you have made and understand that you're not alone to be able to be resilient. So to me, it's extremely important to, and also I guess the last one will be not thinking about safe abortion in a silo, extremely important. Because you really, the power of collective action, you really find strength with numbers. So it's extremely important to keep that in mind. Thank you.
Thank you. I think that's been a wonderful, inspiring, and informative session. I really, really enjoyed it. I hope all of you did too. So let's give a big round of applause. I don't know if you guys want lunch. And I think lunch is there. Yeah, you'll find your way. So lunch until 1 o'clock and then come back here with the regular and wine.
Yeah.
Okay. Thank you, everyone. Enjoy your lunch. Thank you. Yes. Thank you so much. That was great. Thank you, Tabitha. Great. Yeah. Great question. Thank you.
That's very good. Thank you. To the keynote address on the contributions of Professor Charles Ngwena. Because of the time difference, obviously we brought this now so that the speakers, including Professor Cook, who is in Toronto, 6 a.m. We appreciate you being here with us this very early morning as well. I wanted to quickly introduce Professor Cook before she gives her remarks. So what this format will be is that Professor Cook will give her remarks about Professor Ngwena's contribution. Professor Ngwena, welcome. Is also online and will give a quick, perhaps, reflection on Professor Cook's remarks, and then we'll also open it up for interactions as well. In terms of an introduction, I suppose Professor Cook is not a stranger to most of you, but I'll extract a bit of her bio as well. She is Professor Emeriti in the Faculty of Law, the Faculty of Medicine, and the Joint Center for Bioethics, and co-director International Reproductive and Sexual Health Law Program at the University of Toronto. She has served on various advisory boards, including for the WHO, and continues to serve on the editorial issues co-editor of the IJGO, the International Journal of Gynecology and Obstetrics. She has also co-authored amicus briefs on international and comparative gender equality law for various courts, including to the Apex Courts of Argentina, Brazil, Chile, Mexico, and the US, and the European Court of Human Rights, as well as the Inter-American Court of Human Rights. She has over 200 publications, including her most recent edited book, Frontiers of Gender Equality, Transnational Legal Perspectives, which Professor Ngwena also has a chapter as well. Professor Cook is a friend of the center, most especially the Sexual and Reproductive Rights academic program, which she has also taught a number of times as well. Thank you, Professor Cook, for being here, and over to you. Thank you.
Thank you, Satang, and to my friends and colleagues at the Pretoria Center for Human Rights for bringing us together to celebrate the remarkable career of Professor Charles Ngwena, which I am pleased to see continues to flourish. It's a privilege to give this address, to have the opportunity to savor the blessings of friendship and collegiality with Professor Ngwena. I have known him since 2000 when we first met at the World Association of Medical Law Conference in Helsinki, Finland. Our first co-authorship was in 2001, and our most recent co-authored chapter was published this year. In between, there have been many co-authorships, co-editorships, and opportunities to teach in his programs, first at the University of the Free State, and then at the Center for Human Rights of the University of Pretoria. Perhaps most pleasing of all were the relaxing times my husband Bernard Dickens and I spent with Charles and his wonderfully joyful wife, Patricia. I've been asked specifically to address Professor Ngwena's contributions to scholarship. His scholarship ranges across a broad spectrum of issues, including labor law, disability law, constitutional and human rights law, health law, bioethics, reproductive and sexual health law, and rights. Well, I'm best equipped to address his scholarship on reproductive justice. I want to take us to a higher level of abstraction and ask three questions. What characterizes his scholarship? What are some of the scholarly contributions to our understanding of equality? And third, how has his scholarship facilitated dialogue? What characterizes his scholarship? For starters, I would like to identify three features. First, its rigor. Second, the way he puts his body of scholarship in conversation with reality. And third, its insight. Let me take these features in turn. First, its rigor. It is exhaustively researched and skillfully and even beautifully written, suggesting that he takes his work through many, many different drafts. Charles never hesitates to submit his drafts for comment, for improvement. He does not just ask for comments, rather he prefaces his request by saying that he would be especially appreciative of how a certain section might be better framed, or whether an explanation might be better articulated. Second, I want to note Professor Ngwena's particular ability to put theory in conversation with reality to the benefit of both. Here I'm reminded of his scholarship on why transparency is essential to advance the goals of procedural justice, especially in the context of the health sector. That is, the obligations are owed to ensure that laws are sufficiently clear, sufficiently transparent to providers and patients alike, so that the laws can be better implemented in a way that is fair to all concerned. And in addition, are the obligations owed to ensure accessible and timely administrative procedures, including appeal procedures, to allow patients who are unfairly treated to contest such treatment. Professor Ngwena's ability to relate theories of procedural justice with the realities that women face, for instance, in accessing abortion services in many African countries, has feminized and contextualized abstract theories of administrative justice. This scholarship has given new life to theories of administrative justice, sometimes described as due process. Professor Ngwena's advocacy has incentivized health systems to be more transparent in the delivery of health services, especially to women. The third element of his scholarship is the quality of his insight. Professor Ngwena's scholarship is characterized by its insight into the vulnerabilities of the victims of discrimination, sometimes called the discriminatee. Insight as a characteristic of his scholarship is especially apparent when one looks at the trajectory of his scholarship. His scholarship has given new meaning and much needed meaning to justice to particular subgroups of individuals who are subordinated and whose subordination has been neglected or overlooked. Such groups include employees living with HIV/AIDS, pregnant women with AIDS, those with various sexual orientations and gender identities, those with disabilities, those who have been raped or sexually abused, and, for example, those with unwanted pregnancies, including poor women and girls. You might ask from whence this treasured ability for insight comes. I wonder whether it might have come from his experiences in living in different communities, beginning where he was born, in Marondera, Zimbabwe, located 72 kilometers east of Harare. Having examined what are the attributes, some of his attributes that characterize Charles's scholarship, let me turn now to the second question. What are some of the highlights of his scholarship that have contributed to our understanding of equality? His scholarship has expanded the protections of anti-discrimination law from those with immutable characteristics, such as ethnic origin, to include those with mutable or evolving characteristics, such as health or pregnant status. Charles's scholarship has gone beyond single ground discrimination to address intersectional discrimination, such as on grounds of disability, youth, and poverty, to enable a further understanding of the wrongs of discrimination resulting from intersecting or interacting grounds. While his contributions to equality scholarship are multiple, what makes Charles's scholarship distinctive is how it has exposed the structural forms of discrimination, especially those structural forms that are experienced by subgroups of people, such as those living with disabilities. He has shown how his own work, and here I quote, how structural barriers prevent the equal participation of persons with disabilities in social and economic spheres, including the spheres of reproductive autonomy. Achieving equality and eliminating unfair discrimination requires states to take positive steps to accommodate persons with disability. The transformative implications of this approach is that it is not the person with disability who must fit into existing societal arrangements, but rather the arrangements must be restructured to accommodate disability and facilitate equal participation and enjoyment of human rights, end quote. This scholarship has helped to solidify the obligations that flow from rights to non-discrimination. That is, and here I quote again, non-discrimination obligations are unequivocally framed with a view to achieving substantive equality or de facto equality, as opposed to merely formal or de jure equality, to assure not just equality of opportunity, but also equality of outcomes and rendering the socioeconomic environment accessible to persons with disability, end quote. Let me turn now to the third and final question. How has Professor Ngwena's scholarship facilitated dialogue. In his pioneering book, which I have here, What is Africanness? Contesting Nativism in Race, Culture, and Sexuality, Professor Ngwena goes well beyond his central discipline of law to build on social theory to generate intercultural, interdisciplinary, and international dialogue about matters of race, culture, gender, and sexuality. In doing so, his book provides the tools necessary to facilitate dialogue about the cultural and disciplinary structures of our thinking. That is, those structures of thinking that have contributed to a historical tendency towards homogenization when constructing African identities. The relevance of the book's methodology goes well beyond issues of distinguishing African heritage from other heritages, particularly concerning sexual orientation and gender identity, providing us with the vocabularies necessary to challenge our respective thinking. The book has facilitated multiple dialogues across disciplines, cultures, and nations. In conclusion, having explored these three questions about Professor Ngwena's scholarship, I want to speak directly to Charles. Charles, you are a major architect of the fields of health law, sexual and reproductive justice, and disability rights. Through it all, by virtue of your intellectual stature, your remarkable scholarly output, and your reputation as a teacher and as a mentor, you have provided a public voice on some of the most contested issues of our times. You are sought after for your balance, your wisdom, and when appropriate, your penetrating, no-nonsense approach to problems. In your gentlemanly way and your scholarly ways, you have made the unspeakable speakable. In your courageous ways, you have shown how one gets one's point heard and recognized as legitimate. You have motivated and inspired countless others to contribute to the design and building of these fields. You have given unsparingly to your time to review papers of new and seasoned scholars alike, to read innumerable theses and dissertations and book manuscripts, and to provide insightful comments on drafts that inspire authors, many of whom are gathered here today, to run the extra miles needed to meet that standard of excellence. As a gentleman and as a scholar, you have enabled more democratic conversations. In a world where public speech has historically been constructed as male, you have ensured all voices are heard and validated in the public space. For this, and for your manifold scholarly contributions to building justice, let me say on our collective behalves, thanks and ever thanks.
Thank you. Yeah, thank you very much, Professor Cook, for those wonderful words. I mean, especially on the point about rigor and no nonsense. As a former doctoral student of Professor Ngwena, I know that students, when they are assigned supervisors, are quite scared of him. But from my own experience as well, he's also very fair and, as you mentioned, a great mentor as well. And most of the people in the room, but also online as well, can attest to that. Professor Ngwena, do you want to say something in response to Professor Cook?
Well, thank you very much. and good afternoon, everyone. My words are not a response to Professor Cook, but merely words of gratitude to the mentorship that she has generously provided, not just to me, but also to the work that I have been doing over the years. My gratitude would not be complete without mentioning the enormous beginnings of our partnerships in teaching at the University of the Free State. So that was really the point of creation in terms of collaborative teaching, in terms of designing a program for the African region that would, for the very first time on the continent, focus on sexual and reproductive rights. So I'm enormously grateful for the role that Professor Cook played, not just in thinking about how to structure the program, but also how to secure funding for the program. Professor Cook and her husband, Bernard Dickens, shared their time to come to Bloemfontein to teach on the program and to inspire confidence in me as well as my students in taking the discipline of sexual and reproductive health and rights seriously. So by the time that I moved to the University of Pretoria, that partnership had been strengthened, it had been collaborated. So I'm enormously grateful, and I say this without contradiction, that without your participation, I do not think we would have achieved the strides that we made with putting on the ground a curriculum that focuses on sexual and reproductive rights and making it a respectable discipline, even in conservative universities at the time, such as the University of the Free State. So thank you so much for that contribution, and thank you so much for being ready at any given point in time to encourage, but also to comment on drafts and on each occasion that you commented and that your husband, Bernard Dickens, commented. I was able to end up with a better draft. So I'm enormously grateful for that. And most of all, grateful for your humility, your capacity to share your knowledge without expecting anything in return, other than to see that the discipline of sexual and reproductive health and rights flourishes, not just in the part of the world in which you were born, but equally important in all parts of the world. So those would be my comments, that I sat as an African male at the hands of a Canadian-American female, learning all the tricks of the trade. And I'm what I am today, in a large part to the mentorship that you provided me with. So I'm really grateful for that.
Thank you very much, Professor Ngwena. I know that you do not like attention on you, but we're only seeing half of your face. Yes, there you go. Yes.
Right.
Thank you. Thank you. So I wonder whether we have anyone online who wants to reflect, or in person, either reflection or question to both Professor Ngwena as well as Professor Cook. Whilst people are thinking, I do wanted to ask, I think because it's related to the previous panel that we had, which was obviously based on the current book project that we're working on, abortion reform law in Africa, about your recent co-authored chapter that the two of you have in the book edited by Professor Cook. If you can say a little bit about that book chapter, I think that would be great for the folks in the room as well as those online as well. Either of you can go first, whoever wants to go first.
I would defer to Professor Cook, then I can come
Okay.
after her.
I was going to start since Charles is the first author on this chapter, but what we wanted to do was to take this case against May Mapinguri brought against the government of Zimbabwe and rewrite the decision of the Supreme Court of Zimbabwe using the rewriting examples from other feminist rewriting projects. In particular, we built upon the rewriting project here in Canada, whereby the rewrites were done along the grounds of equality. Much of the jurisprudence on the abortion jurisprudence is based upon, here in Canada, rights of security of the person, or in the US, privacy. But we wanted to secure the right of equality when it comes to abortion problems. And so we wrote it around the grounds of equality to show how the health system is structured in very unequal ways to neglect the healthcare needs of women. We built upon the CEDAW recommendation 24 that clearly states that neglecting or overlooking healthcare needs of women is a form of discrimination against women. So the rewriting part of the chapter, the second part of the chapter, followed Charles's work around putting this in a historical perspective on colonialism, and I'll let Charles speak to that.
No, thank you very much, Rebecca. And I will be the first to say that the chapter was really an opportunity for me to learn from Rebecca, her enormous expertise in thinking about the relationship between women and health systems and placing them in positions where they could question what was being done to them, what was being denied from them, but using arguments that are based on the rights of women. So when you read the chapter, it is really an excavation of the relationship between Mai Mapingure and the constitutional rights that are guaranteed to her by the recent constitution in Zimbabwe, the constitution of 2013, and how that constitution also intersects with the international human rights framework, not least the Convention on the Elimination of All Forms of Discrimination against Women. So what we wanted to do in many ways was to give life to the Constitution of 2013 and remind civil society, human rights defenders, that there is a lot in the Constitution that would lead to a different outcome were the same facts to arise. And I'm so happy that civil society in Zimbabwe are beginning to read the book and to think afresh and to realize the enormous potential of their own constitution in Zimbabwe and how it can be used to question some of what was thought to be beyond question. So that's what I would like to say.
I should say, for people that don't know the Mapinguri decision, this was a woman who was raped and was denied abortion for purposes of rape, which is legal in Zimbabwe, but she was denied access to abortion for those purposes. So it was the health system that neglected her needs in many, many different ways. So we rewrote it according to her rights to equality within the healthcare system, not only in terms of the unfair procedures, but also in terms of her rights to non-discrimination on grounds of gender, pregnancy, and socioeconomic status. She was a very poor woman and could only access abortion through the public health system. The other thing we did was to make sure that it was discrimination on grounds of pregnancy. I think one of the ways that the reproductive movement could be much stronger is to use pregnancy as a grounds of discrimination. And most recently, even thinking about defiled status as a ground of discrimination. Her rights to the equal exercise of other rights, we also explored, particular her equal exercise of her freedom of conscience, her equal exercise of the right not to be treated in degrading ways, and her rights, of course, her equal rights to access to healthcare services. So we looked at the equal exercise of rights as well as the right to non-discrimination on grounds of gender, pregnant status, and socioeconomic status. I hope she's gotten a copy of this chapter. I don't know.
Me? Thank you very much. And I do have a copy of the book, actually. So Professor Bart Lockwood sent me a copy. So yeah, I don't know. I'm sure other people don't have it. Anyway, do we have any other questions? I think there were several comments in the chat. So Tabitha said, no questions, just appreciation and gratitude to Professor Ngwena for his mentorship. Uncle Charles infused those 3 lessons that Rebecca Cook shared to many of us feminists here in Kenya. I speak on behalf of a large flock of us who have abused his generosity with time, wisdom, and so many times. Love, Tabitha and the crew from Kenya, including Mariam, Sophia, and others as well. Thank you, Tabitha. Professor Holness also said, thank you to Professor Charles for his mentorship through the years. I'm eternally grateful. And Aina wants to know where she can get the book.
If she wants to review the book, I can definitely arrange for a copy to be sent free to her if she sends me her address and the journal in which she would like to review the book. It's University of Pennsylvania Press, and there is a website for the book, frontiersofgenderequality.org.
Yes, Professor Ebenezer, do you want to just come in front so you have the camera on you? You have a question? They wouldn't hear you otherwise. No, they cannot hear you. Okay.
Good afternoon, Prof.
Oh, good afternoon, Ebenezer.
Let me just start by saying I'm very privileged to have the 2 of you. They are my supervisors for my doctorate at the Free State there, University of Free State there. And since then, we have also been in touch, working together on 1 or 2 things. So my question will be first to Professor Cook, and then I'll come to Professor Ngwena. I wanted to Professor Cook to just share some tips with us, how you have helped all this year, even after you retired from Toronto, keep relevant in terms of your contribution to knowledge in this field. What are the, should I say, the tips you will share with us in terms of how to sustain that kind of relevance for a long time you have done in your career? And then to Professor Ngwena, I do know that the LLM program where you started at Free State was modeled along the international program at Toronto. And then looking back from Free State to now, what are the things do you think you would have loved to see that you have not seen?
The tips I can share are really very much what I emphasized about Professor Ngwena's contributions to his scholarship. The rigor, his ability to put theory in conversation with reality, and his insight. I think in terms of the rigor, one thinks that one could do a first draft and that would be enough. But I learned through my work and watching his work how many drafts you have to go through to really articulate an idea and to make it clear. I myself subject my drafts to a variety of different people, but perhaps my harshest critic is my husband, and he doesn't let me get away with 2 or 3 drafts. It's 4 or 5 drafts that we go through, and I have to say I'm far better for that ability to have somebody read my drafts. I also try very hard to have people from different perspectives read my drafts, because it's so important to bring in perspective in one's work, particularly from those who you don't agree with, so you know that you're adequately addressing those perspectives. Putting theory in conversation with reality. I guess I started working way back with International Planned Parenthood, and I was dealing with the everyday realities of women's access to reproductive services. And it took me a while before I understood how to put theory in conversation with reality. And here, Professor Ngwena's work around thinking about different forms of justice, whether it's distributive justice, procedural justice, has been very helpful to my thinking. But it requires one to read both in theory and in, say, the public health literature to understand the reality. The third quality for insight, the third quality of Professor Ngwena's scholarship is his insight. And I can't say enough about the importance of insight. I think when one thinks about an individual, about, say, my nieces and nephews, my siblings, I always say to myself whether they have insight. And sometimes my sister, who calls a spade, will say, I'm not sure that person can change because that person doesn't have insight. And that's a very damning quality. And often what I do when I see qualities in others that I don't appreciate, I try to make sure I don't have those qualities. So one's ability for insight, it can grow over time, but it's absolutely critical to one's being and one's scholarship. And if you read Professor Ngwena's scholarship really carefully, in many different ways, his ability for insight is really quite remarkable. And I really would love to ask him where it comes from. When I noticed, I had to look up on the map where Marandera is, and I thought, I wonder, it's not too far from the border with Mozambique. So I thought, well, maybe his insight for thinking about other people from in other languages might come from where he was born and the community into which he was born. But one's ability for insight is so critical to functioning in this world, not only as an academic, but as a human being. And I certainly have appreciated watching how Professor Ngwena has developed his insight over the years. So those are a few thoughts on tips, but all derived from the wonderful experience of working with Professor Ngwena.
Well, thank you for that, Rebecca. I can partly answer one of the questions you raised. I think all writing is biographical in a way. We don't always explain what has motivated you to be so, and some would say obsessed with equality. Why do you think so much about social groups that are excluded? And I remember some of my sister-in-laws asking, why is Charles so concerned about women and abortion? And why is he so concerned about unpopular? But I think all writing is biographical. It relates, I think, back to my being born in Rhodesia at the time, as somebody who was able to see that I was really outside the mainstream of what that society believed to be human. And that inspired me to think, well, if I'm going to remedy my own individual position, I can't do it by simply thinking about myself. I have to think of others who might also be excluded by social and political frameworks because they are outside the mainstream. So the people that I've associated with, the people that I've collaborated with, the people that I've worked with have also a similar. So it's a very interesting dynamic that it's not that they are not concerned about stability in society and how easy it is just to accept for things that happened yesterday to continue today. But all of my collaborators have challenged the status quo, but they've done it on principled grounds. They've given reasons why the status quo should not be left undisturbed because it leaves out other human beings. So it's about human dignity. That would be my explanation, that I was born in a society where the social group in which I came from was marginalized and excluded. And I felt that I owed society a debt to do the little you can, because you can never do everything. But I think the little you can matters because it also influences others to do something similar. My sense of fairness is something that was enhanced by my collaboration with Rebecca. I don't want to embarrass Rebecca, but Rebecca is unique in her sense of treating people equally. And I'm not saying it as a lone voice. All the people that I've worked with who know Rebecca have repeated that sentiment, that she adds to humanity what in most instances is missing: the idea that we can be a global community, we can be a human community, even though there are inequalities. We can find ways of addressing those inequalities and collectively work for a better future.
Thank you, Professor Ngwena. I think Ebenezer's second part of the question about what you will have wanted to see with the transformation from the academic program in the Free State to the University of Pretoria, and what ideally what you would have wanted.
I think I can give some sketchy responses. One, and this is not to exclude you, Ebenezer, and myself, I would like to see more African women leading the program because this is so important in a continent where men have spoken for women. I think it's time that we take this obligation seriously. We create space for women to contribute to the betterment of sexual and reproductive health and rights at all levels, including at the level of teaching in universities. So that is one actually goal that we had from the very beginning, was to ensure that we do not once again create a program that would center men and marginalized women. The other, I suppose, consideration would be that as we think about sexual and reproductive health and rights, let us also think about historically marginalized causes. And this afternoon, we shall speak about gender affirming care as an instance of an area that has been marginalized over time. And we need to bring those areas into the mainstream of how we do sexual and reproductive health and rights. Another thought that I have is to work more closely with civil society so that we do not end up with a theoretical archive of knowledge that does not have a connection with the aspirations on the ground. But I think the Center for Human Rights at Pretoria is really good at this. So the program, I believe, is appropriately located in a department of a university which is equally connected with civil society. So those will be my short comments.
Yeah.
So thank you, Professor Ngwena. So one of the things I picked up this morning is the growing upsurge, in anti-abortion advocacy in many places in Africa, places that it was not very obvious. So I wanted to pick your thoughts on how should we respond, first theoretically and conceptually, to this anti-abortion advocacy, and then two, how should we respond practically? So practically in the sense of policy, but also in terms of how we actually go about making sure that services are accessible. Thank you.
Okay, could you say who you are so that I have?
Sorry, John Ganley.
Oh, right. Thank you very much, John.
Thank you.
Sorry, we've never met. John is an author, a co-author on the book that we are
Yes.
editing. And I really must say that you produced a fantastic chapter, and we're very grateful for the thoroughness with which you wrote the chapter. Let me try and answer, and I don't think I have all the answers, and hopefully Professor Cook might also have something to add. I remember many years ago when we spoke about the enormous achievements of South Africa in developing a law on abortion, which was different from other laws on the African region as well as beyond the African region. The Choice on Termination of Pregnancy Act of 1996, which was implemented in 1997. And I remember being in a conference with Marge Bearer. She used to be the editor of what is now the journal called Sexual and Reproductive Health Matters. We were so excited about the South African law and how sensitive it was in centering women. But Marge Bearer said the point about abortion is that you can never really celebrate too much, because after a while, that law engenders a backlash. Someone will come to challenge it. Someone will want to roll back. And we've seen this play out in the United States recently with the pushing back of Roe and Wade. So I think it's incumbent upon civil society not to rest on its laurels, to always be vigilant, to always ensure that at any given point in time, we are mapping opposition against the liberalization of abortion. And we have an understanding of where that opposition comes from, so that we can also find champions, including finding champions in the legislatures, in the ministries of health, who can protect the gains. I think one of the mistakes that the advocacy of abortion can make is to overlook that within ministries of health, there are always a minority in the African region who are committed to ensuring that women are not exposed to unsafe abortion. It's important to have allies in government, not just in civil society, because in the end, you can't really change much without government support. You can't really change much without also having allies in the healthcare sector. It is important to be in contact, in conversation with the doctors, with the nurses, with the midwives, so that any progress that we make is progress that has purchase from the sectors that are closely involved with the provision of services. So those will be my initial comments, that what we are seeing on the African continent today is something that we perhaps could have anticipated. We could have anticipated that religious authorities would in part be sponsored by their counterparts in other parts of the world, but more particularly by the evangelical constituencies in the United States, who, as we all know, are very much opposed to ensuring that women are free to decide about their sexuality, they are free to decide about their reproductive choices. So those will be my brief comments. I'm not sure whether Professor Cook might have something to add to what I've just been saying.
Well, just to underscore what you've been saying, Charles, on the point of backlash, in our chapter on Maymap and Guri, we do cite to some really important scholarship on backlash. I think with any movement, one can't ignore that there are going to be backlashes. And the literature to which we cite in that chapter is really backlash against racial integration. So there is a body of literature about backlash in different social movements that I think we in the reproductive justice movement could do well to consider how to bring that learning into our movement. So you have to expect backlash in any movement and think about how best to counteract it from the very beginning. That's one point. The other point that I'm not sure the movement, well, let's put it this way, the movement could do a better job in showing how we respect prenatal life. I mean, prenatal life is a very important social value, and it has to be protected consistently with women's rights. And this is another point we make in our chapter, particularly with women's rights to equality. Now, there are many ways of supporting prenatal life consistently with women's rights, including the reduction of stillbirths. And in the case of Zimbabwe, we cite the literature on quite a high rate of stillbirth in Zimbabwe. so one needs to look at how to protect prenatal life consistently with women's rights, whether it's the reduction of stillbirths, whether it's the reduction of maternal mortality, preventing maternal deaths, to really inform our respective communities about a more comprehensive approach to the protection of prenatal life, and in ways that do protect women's autonomy and their equality. The final point I'll make is, yes, there is backlash, but don't forget some of the achievements. And here, what is happening in different courts in different parts of the world. For example, the Colombian Constitutional Court has come out with an excellent decision on abortion, and it is there's a commentary on that decision in the International Journal of Gynecology and Obstetrics in the ethical and legal section that Charles and I and my husband co-edit. There's an excellent article by Isabella Yarmillo on a recent Colombian court decision. Also this year, there's a very important decision out of the Supreme Court of Mexico, and we have an article commissioned on that decision. Both of these are decisions that are very progressive, very much in support of women's rights in the area of reproduction and specifically in abortion. So while there are backlashes, we need to continually emphasize some of the progress that is being made, not in the area of judicial decisions. So those are just a few points.
Thank you. Anyone else? Any last questions online? I know I just saw Professor Franz join us. Thank you, Professor Franz, for joining us. Two quick plugs whilst we have both Professor Ngwena and Professor Cook here. One is about legal grounds. I don't know whether you wanted to quickly just say something about that. You also mentioned Professor Ngwena's book, What is Africanness? We'll share the link. It is available open access on Pulp, and it was the 100th publication back when it was published. And there is also a fantastic podcast as well, and we'll share the link. But if you wanted to just quickly, Professor Cook, talk about legal grounds, and then if Professor Franz wants to, he put on his video, good seeing you, wanted to jump in as well.
Thank you, Satang, for that question about legal grounds. Charles, has it been three editions of legal grounds that we've gone through?
Yeah, it's 3.
And now it's all online. And this is a project where we've collaborated our respective programs on working with Professor Ngwena's students to get case comments on African court decisions dealing with sexual and reproductive rights. I'm sure people at this meeting have done some of those comments. And this is, in essence, am I right, Charles? What we're doing is hold judges' feet to their fire.
Yes, something like
sure. and some of them, it's the beginning of thinking about court decisions. Some could go on. There is a whole African project on rewriting court decisions, so some of these decisions could also be rewritten. But it's time, if anybody who's attending this conference knows of court decisions that needs case comments, we would welcome those comments. And they go up on Afric Law, they go up on the Legal Grounds website. Have I covered? And they're across the broad spectrum of reproductive and sexual rights.
Great. Thanks. Professor Franz, I'm putting you on the spot. Did you want to say something? I will ask him.
Hello, Satang, and good morning, or from my side of the world, same side as Charles. Professor Charles, great to be here. I'm apologizing. I had some difficulties connecting, so I didn't hear all, I'm sure, the lovely words that Rebecca directed. And I think we have a session tomorrow in which I think we will also revert back to these. So just to say good day to everyone and wonderful event. Thank you very much. And, revert later. Thank you.
Thank you, Professor Franz. Professor Cook, I know Professor Ngwena is on the next session, but did you want to have any last words before we close out this session?
I think just to underscore my congratulations to Charles on his manifold contributions, and to thanks to the Center for Human Rights at the University of Pretoria for bringing us all together to celebrate Charles, his scholarship, his mentorship, and his wisdom. And thank you all for making this happen.
Thank you very much, Professor Cook, and on behalf of the Center to say thank you, but also thank you to Professor Dickens. I know he's not joining us, but has always been here with you as well during the academic program. And also to say, Professor Ngwena, that even though we haven't seen her, but Patricia obviously is in the background, this is as much of a celebration of you as her as well. So also to say congratulations and thank you to her. So at this point, we'll take a quick break, I think about 10 minutes, and then we'll be back.
Why is the issue of access to healthcare relevant and important for persons that are identifying with transgender and gender diversity? I would like to ask the question, is there a framework? How do we name? Because naming is an important part of how we realize rights. I would like to say something about the concept of gender affirming care, as well as the philosophy behind advocating for gender affirming care. And I will complete my initial remarks by speaking about equality. How should we think about equality in the context of gender affirming care? So I begin with the question, why the issue of access to healthcare is relevant and important in this area. And in part, I am answering a question raised by Professor Durojai. One of the questions he raised was to do with what could we do different, or what could we add to existing teaching or curricula on sexual and reproductive health and rights. And clearly what we want to ensure is that we also include in the curriculum topics that have not been rendered visible or that have been marginalized. And I believe that gender affirming care has generally been marginalized in discourses on health and human rights. So to answer the question, why is the issue of healthcare relevant and important? I would like to highlight that gender identity should be considered, or argue gender identity should be considered as a social determinant of health, meaning we should no longer confine our understanding of social determinants of health to the way that they were initially conceived by many social bodies, as well as health authorities, such as the World Health Organization. We should continuously expand that archive so that we can say gender identity should also be added to the list of factors that we describe as social determinants of health. We know, of course, that in the African region, there are enormous gaps in research and knowledge about the healthcare needs of transgender and gender diverse Africans, whether as children, whether as adolescents or adults. But at the same time, there has been some research done already. Situational studies confirm that transgender and gender diverse Africans experience multiple barriers and intersectional discrimination in access to healthcare. And clearly, those barriers are made worse by laws that criminalize sex between adults or consenting persons of the same gender. So this is something that brings the issue to the core. Gender identity in the healthcare sector as outside the healthcare sector is stratified, and privileges accorded to cisgenders. By that we mean genders that conform to the symmetrical gender binaries of male and female. Gender identity is a social determinant of health because gender stratification is causally connected with gender-related health disparities. Gender minorities experience stigma, discrimination, violence, which collectively serve to exclude or marginalize gender, or rather transgender and gender diverse communities from healthcare. So that would be the first point, why the issue is important. We can ask the question, now, is there a framework for recognizing gender identity as a social determinant of health? And more specifically, is there a framework for recognizing gender identity as a constitutional right or a human right? And we know that gender identity is not explicitly guaranteed as a discrete right in our prevailing human rights treaties or domestic constitutions. However, in recent years, a number of important gains have been made. The most important gain in terms of the jurisprudence was the adoption of the Yogyakarta principles in 2006. These principles, which are really soft law, have transformed global awareness about gender identity, as well as the normative content of the human rights of transgender and gender diverse persons. The Yogyakarta principles address sexual orientation. They also address the rights of gender minorities. Significantly, the principles, we can agree, have achieved the status of global soft law that provides guidance on the normative application of international human rights to sexual orientation and gender identity by UN mechanisms and treaty bodies, and by extension, by regional treaty bodies and domestic courts. Another important development in the development of a framework for recognizing gender identity as a human right was the creation in 2016 of a dedicated United Nations mechanism for protecting sexual and gender minorities against violence and discrimination. This is the Office of the Independent Expert on Protection against Violence and Discrimination based on sexual orientation and gender identity. So this is a further cap in the transformation or in the recognition of gender identity as an important human right. In recent years, coming to the African region itself, in recent years, there have also been some incremental developments. I think the most important development was in 2014, adoption of a resolution 275 by the African Commission on Human and People's Rights to express grave concern about violence and other human rights violations that target sexual and gender minorities. But one would say clearly, this is a beginning for the African region in terms of the human rights framework. I can add other developments at the regional level, such as in 2017, when adopting General Comment number 4, the African Commission expressed an opinion that gender identity is among the grounds implied in other status in Article 2 of the African Charter. We can also add to that in 2018, the African Commission participated in a joint dialogue with the Inter-American Commission on Human Rights and the United Nations Mechanism on Ending Violence, Criminalization, Discrimination, and other forms of human rights violations against sexual and gender minorities. And one would say that notwithstanding the seeming confinement of recent developments in the African region, the seeming confinement to protection against homophobic and transphobic violence, the engagement with gender identity in the African region paves the way for giving attention to wider and more holistic human rights protection. Because protection of sexual and gender minorities against violence cannot be realized without taking additional steps to fully recognize the human rights of transgender and gender diverse persons, not least their rights to human dignity, equality, and non-discrimination across all sectors of social and economic life, including the healthcare sector. We can ask the question in terms of framework, have there been any developments in the individual African countries in terms of recognizing the rights of gender minorities? Yes, there have been in Botswana and in Kenya, in South Africa, and in Zimbabwe. We can point to judgments that have been passed affirming directly or indirectly a fundamental right to gender identity and expression under domestic constitution. So this is a plus, notwithstanding that the countries are in a minority rather than a majority. We can also point to soft law developments. We can mention here the World Health Organization and its position on gender affirming care as a human right. The World Health Organization recognizes that access to gender affirming care is a human right and is an integral part of fulfilling the right to health under international human rights frameworks. One question I also would like to address is naming. How do we name the phenomena we are discussing? How do we name the phenomena of persons who do not conform rather to the sex assigned at birth. I think this is important for Africans because the naming we have has largely originated from a Western archive. It is really a manifestation of the globalization of gender systems. Do we call it transgender? Will that be enough? So my point here is really just to remind us in the African region that the term transgender gained popularity in the 90s as a shorthand for recognizing transgressive genders. It replaced the term transsexual. Transsexual had been used in a social and political context where hormonal therapies and gender surgeries had been validated by the medical profession and we're becoming increasingly accessible to populations in industrialized countries as a way of altering bodily form, including sex characteristics, to align with the individual's gender identity. We also know that semantically or linguistically, transgender is often understood as a binary transitioning or a crossing over from one identifiable gender to another identifiable gender, often with the accompaniment of gender-affirming therapies or surgeries. So my point is that when used uncritically in an African context, transgender can be a colonizing term because it has been built against the notion of a wrong body narrative that privileges, in my view, Western identity while alienating persons from other cultures whose gender identity may not be non-binary or have no access or have indeed no desire for gender-affirming therapies. In other words, persons in the African region who derive gender identity from indigenous life worlds or spiritualities are not easily accommodated by a term that derives from a Western conceptualization of gender. Now, this should not be understood or misunderstood as saying that using the term transgender has no value for advocacy. Of course, it has value for advocacy. So my point is really whether it fully captures the epistemology of gender identities in the African region. So I'm advocating, and not for the first time, I'm advocating for the use of the term transgender and gender diverse as a response to the call by African trans communities and activists to use language that is maximally inclusive and does not erase or exclude other gender diverse identity. So in so doing, I'm also aligning myself with how this term is used by the World Professional Association for Transgender Health. This is an international multidisciplinary professional association which seeks to promote care, education, research, public policy, and respect in terms of transgender and gender diverse health. I ask another question, what is gender affirmation? Or what is gender affirming care? So to understand gender affirming care, we need first to understand what is gender affirmation. And needless to say that cisgenders have no need for affirmation because our social arrangements are designed to implicitly affirm those with gender identities that conform to symmetrical binaries of male and female. However, if you fall outside that framework, if you are marginalized, if you're excluded, you have need for gender affirmation because you are going to interact with social institutions that exclude or marginalize you. So I would say that we already have an archive of what gender affirmation is. Gender affirmation is not a once and for all event, but it is a phenomenon that can be broken into four main domains. One is the social domain, which is about how an individual wishes their gender to be acknowledged during social interactions at home or at work or in institutions, such as through their name, their pronoun, or gender presentation in clothing or mannerism. The second domain, not in any order, is the psychological domain, which is about individual self-validation of gender identity. And the third one is the medical domain or the health care domain, which comprises of medical and surgical interventions that are medically necessary and it's important, wanted by the individual to affirm gender identity, such as puberty blockers, hormones, reproductive options, and surgeries, voice and communication therapies. And fourth is the legal domain, which is about the right to enjoy recognition of one's gender identity under the law in all manifestation. It includes the right to a legal name change, the right to a legal gender marker change, the right to freedom from discrimination on the basis of gender identity in all aspects of social and economic life. So these domains are not linear. They are not a one-size-fits-all. Affirmation does not mean going through all four domains. Some transgender persons and gender diverse persons may choose to go through social affirmation only, but others may require the other, I beg your pardon, dimension. So when it comes to the healthcare system, we would say that gender affirming care is the integration of the four key gender affirmation domains, that is the social, the psychological, the medical, and the legal, into the healthcare system that have been historically built on cisgenders or cisgenderism. In other words, gender affirming care is healthcare that is holistically responsive to social, mental, and physical needs, and to supporting and affirming a person's gender affirmative identity. And it's important to emphasize that gender affirming care is not limited to therapies for modifying the body, such as hormonal therapy or surgeries. It goes beyond the medical to also attend to the social, the psychological, and the legal domains. What about the philosophy what kind of philosophy can we bring to claims for gender affirming care? In the African region, I think debates are no longer complete without tapping into indigenous philosophies for inclusion. And one widely discussed philosophy is the philosophy of Ubuntu. Apart from looking at human rights, we can tap into indigenous philosophies to enhance the claim to gender affirming care. We can frame it as a demand for recognition of human dignity. In African moral thought, human dignity is protected by the value of what is or can be described as the philosophy of Ubuntu. It's known by different terms in different parts of the African region, and in shorthand, it translates into saying, I am because you are. In its decolonial sense, Ubuntu can be used as an inclusive value for affirming the dignity of every human being, their connectedness to and interdependence on other members of the community, regardless of gender identity. So for the Africans, Ubuntu serves to protect human dignity by deconstructing the injustice of colonial regimes that introduced to the African continent homophobic and transphobic discourses that maligned and disciplined sexual and gender minorities, rendering them outsiders, disconnected from the community with others. So in its holistic construction of the human, we would argue Ubuntu enables Africans to challenge colonizing structures that systematically exclude certain groups from equal participation in community. And in its place, it is intended to foster community development. So what kind of jurisprudence can we advocate for the recognition of gender affirming care? I would argue equality is our archive. We can think of equality as inclusive equality, and it's important to think about it as a normative content that is made up of 4 intersecting domains. And what are these? One is a recognition domain, a recognition dimension to combat stigma, stereotyping, prejudice, and violence, so that we recognize the dignity of human beings and their intersectionality. The second dimension is a participatory dimension to affirm the social nature of humans as members of social groups and the full recognition of human dignity, of humanity through inclusion in society. A third dimension is an accommodation dimension, so that we make space for difference as a consequence of recognizing human diversity. And fourth, it would not be complete in particular as we think of gender affirming care and access to healthcare, not to think of the importance of fair redistribution so that we address socioeconomic needs and disadvantages. So just to sum up my thoughts, if I go back to the beginning, the title is about framing. I've tried to really sketch some of the components, not all of them. I'm sure I've missed some, but in essence, I've been trying to ask myself questions. Why is access to gender affirming care important? Do we have a framework for it? What kind of naming can we use? And what is gender affirming care? And what philosophy can we use and what kind of equality are we looking for? So I'll stop there and allow Noah and Alexandra to come in.
Right. Thank you so much, Prof. And thank you for the history on quite a robust or outlining of the frameworks that are in place, both soft laws and a couple of hard law mechanisms. And I think that's when countries such as South Africa is quite unique, where we have the right to freedom from discrimination on the grounds of gender identity in our constitution. That's something we need to advocate for across the globe. But let us move on to our next speaker then, and I'll call upon Noah to please take the floor. Thanks.
Thank you so much, everyone. I hope you can hear me quite clearly. My name is Noah Mirembe. I am a Ugandan lawyer, trained as a lawyer and a researcher on gender and sexuality in Africa broadly, but a particular interest in Uganda, which is where I am originally from. Currently based in Kingston, Ontario at Queen's University, where I'm researching on the history of gender diversity in Uganda, northern Uganda, from the 19th century. Still early days, so I'll have more clarity on the project as I keep working on it. I'm really honored to be here today and want to thank in a special way Professor Charles Ngwena for the opportunity to participate on this panel and to speak at this conference, share some of our experiences and the work that I've been engaged with, and also to engage with the ideas around gender affirming healthcare, advancing gender affirming healthcare for trans people in Africa, and particularly from a Southern Africa perspective, speaking to, from, with other parts of the continent. I'm really privileged to speak today because I think this is a topic that's continuously evolving, as Professor Ngwena has laid out, and also speaks directly to the themes of the conference broadly around sexual and reproductive health and rights, both within the gains that have been made, but also some of the setbacks that have been highlighted in terms of, gains in terms of legal protections and policies, and setbacks and backlash in terms of social movements and cultural awareness, and also mobilizations around that. I want to speak to two main themes around gender affirming healthcare. One is to situate the conversation and tying it to, I had the privilege of listening to Professor Cook earlier, and one of the qualities that she highlighted from Professor Ngwena's work was the ability to relate scholarship to the real world. And so my first task here is an attempt at that invitation by linking some of the experiences and conversations around equality and dignity and access to health services and resources, laying a historical context, I think from an activist perspective, and then hopefully tying that into a more contemporary call in terms of what we, as a member of the community, but also part of a collective that's working towards access, for increasing access for a wider number of people, is speaking to some of the other themes that are really important to community. So on the background part, we'll start with equality and dignity. I think Professor Ngwena rightfully laid out the foundations, the human rights foundations that make it possible for us to articulate demands for autonomy, demands for protection, and demands for dignity within the law. When we ask a question, how do we name what we are talking about? I think an important aspect for us to consider is the question of language, as we have already pointed out. In my own scholarship, part of what has brought more and more curiosity into studying the theme of gender diversity has been the gap between the language that we have in institutional and formal structures where resources are distributed. So we are talking about sexual and reproductive health and rights being a rights framework that offers legal protections. At the same time, in many places outside of the academy and outside of legal spaces, at community level, those legal standards don't always translate directly. And what I mean by that is that we constantly, as community, have to negotiate where the protections are anchored in terms of the law, in terms of the healthcare system, and making that kind of language accessible for community members in order to empower a demand for these services. Of course, this is not to say that people are being recruited or indeed affirmed into becoming transgenders, as the narrative goes these days, but rather to offer meaningful language for people to find community and for people to access resources, in particular public resources. So in terms of equality, I think a major theme for trans community and gender diverse communities is the issue of bodily autonomy. I think one of the issues we constantly encounter is that in the search for legal equality is the demand from a legal and medical perspective to undertake medical interventions or perhaps even legal interventions that are not always coherent with our own individual identities. So I understand, of course, as today we are speaking about sexual and reproductive health and rights, which of course sits within a legal and medical framework. But one of the important gaps to point out is that bridge between people being able to express individual identities, which Professor Ngwena terms as the idea of transgender versus the idea of a transsexual, and whether this is language that is really accessible to communities. I found that for most parts, individuals may not have access to that language, but do have demands around healthcare needs or access to different aspects of their identity. And this for me is a really important conversation to have, because empowering the communities that we work with to have the language to be able to ask the right kind of services for themselves is really, really important to ensure that sexual and reproductive health is not just a correcting tool, but also an empowering and wholesome tool that enables people to self-actualize and to meet their full capabilities. Now, the second aspect to that linked to equality then and bodily autonomy is then the aspect of dignity, is in being able to articulate those identities and the multiplicities that there are in those identities, is in having our communities, our healthcare providers have the capacity to recognize those identities and also to respect them in a manner that ensures freedom from violence in particular. Once you start to express that bodily autonomy, once you start to articulate those healthcare needs, outside of these normative frameworks, to challenge the binaries, to challenge and say, I, as a transmasculine person, also need access to abortion services, also need a guarantee for access to, gynecological services. Such expressions usually attract violence, both from within healthcare providers and within legal responses because of the limited frameworks. So it's really important for us as an aspect of dignity to be able to ensure that within SRHR services, we're also talking about freedom from violence as an essential kind of driver or axis for that kind of freedom of expression and wholesome enjoyment of sexual and reproductive health and rights. What that means in the current time is that we have opportunities, and I think I would stand corrected on this, but I do believe that we have an opportunity to utilize tools, policy tools that we have at the regional level. For instance, the 2014 resolution 275 on real or imputed sexual orientation and gender identity is a much underutilized legal tool in terms of protection from violence, but also advancing the dignity for trans communities, both outside of healthcare services, but also within healthcare services. Lastly, this directly has links to why I'm talking about dignity and equality, is especially linked to access to health services and resources, that the ability to express bodily autonomy and to have language and the ability to feel safe from freedom of violence is directly linked to the ability to access health services in a safe and timely manner for our communities. What this means is that we constantly have to maintain our awareness, as Professor Ngwena has pointed out, around the social determinants of health. Within our community, that means a comprehensive understanding of safety, housing, for instance, an understanding of non-discrimination, an understanding of access to public services, an understanding of access to financial resources as key determinants of health outcomes for the trans and gender diverse community. Lastly, for health in particular, I believe that we have opportunities to harness technology as we are doing now. We are, I quite firmly believe, at the new frontier of access and of advancing sexual and reproductive health and services. Why do I say this? Currently, some of the projects I'm involved in very much hinge on access to technology as a primary tool, as a bridge that brings key resources together, the knowledge that we are sharing today, having access to Professor Ngwena, Professor Cook, and my colleagues at the Center for Human Rights in Pretoria, are really key resources to be able to bridge the kind of knowledge that we have. We are bringing activist concerns to the academic space and creating room for us to be able to have these conversations. What that means in reverse is that for communities, we're looking for answers right now. We're looking for ways to ensure that health systems are responsive, drawing the lessons that we have from places like South Africa to ensure that we can speak to healthcare systems within our own countries. And I'm sure my colleague Alessandra will speak to this, especially in a Kenyan and also regional perspective. And also lastly is to ensure urgent bridging of resources. So things like access to goods and services. Healthcare providers are more accessible now thanks to technology. It's an invitation that I continue to extend every time I have an opportunity to speak at platforms like this, to invite our healthcare colleagues to look at their practices, not just as impacting their scholarly and academic, scholarly in terms of academic, but also medical practices as not just impacting national level, but also in constant conversation with other colleagues, particularly in Africa, and in places where criminalization is still a major barrier to access of health services. This means creating platforms for more of these conversations. We can harness technology to create conversations with healthcare providers, conversations with legal providers, conversations with academics like this, and collaborations to work and produce knowledge. All of this seems quite nascent, but is really a foundation to expanding access to gender affirming healthcare in Africa. Thank you so much for your audience today. I very much look forward to hearing from my other colleagues on the panel and also taking questions later on. Thank you.
Thank you so much, Noah. That was very interesting. And I think especially for me speaking to the realization of socioeconomic rights broadly in order to really realize and recognize the access to healthcare is what is needed. So then let us move on to our final panelist, and that will be Alessandra. If you are with us, please, you can also take the floor. Not physically, no. Do we know if Alessandra is here or in the chat? Hasn't been. Okay. If Alessandra isn't with us right now, I think then in the meantime, we could perhaps move on to any questions, if folks have any. Any here or in the chat, you're welcome to pop it down or raise your hand.
Can I ask a question, which is interesting because I'm on the panel, but since I have Professor Ngwena here, I might ask a couple of questions.
Yes, please.
I'm quite keen to hear Professor Ngwena's perspective, especially from a historical lens. You know, I'm interested in his work on Africanness and African identity. My own work has been discovering trans gender diverse expressions from the 19th century in northern Uganda. And I'm quite keen to learn from your perspective, Professor Ngwena, if you found this in sexual and reproductive health and rights. I think that there are quite interesting links now, in my opinion, between 19th century developments on sexual and reproductive health in Uganda, for instance. For instance, funding. I find that the conversations we're having about external funding, in fact, are not new, because as far as 100 years ago, a lot of the work that was happening around sexual and reproductive health and rights was also externally funded. So those historical linkages are interesting. But in particular, I'm curious if you found any particular expressions of gender diversity in terms of sexual and reproductive health and rights in terms of trans and gender diverse people from a colonial or pre-colonial perspective, especially considering early colonial encounters with birth rates and birth records and maternal health and interventions like that. I think there's some, I wonder if you found anything, any historical linkages that we can draw from that. And then a more contemporary question would be around what, you know, what kind of community perspective, how would you say, you know, your own expertise has been around bringing scholarship to life in real world ways. And I'm curious how you would mirror that back, how you'd see communities mirroring that back. How have you seen contemporary communities now receiving and engaging with your work? As a scholar activist, I've been engaged with your work in an academic perspective, but I'm quite curious if you've seen activists in particular engage with your scholarship in gender diversity in particular, and how they've taken that forward. Yeah.
No, thank you, Noah, for those very difficult questions to answer, because part of our legacy, as you know, part of our legacy is an education system that was constructed by the colonial authorities for us and channeled us to look for information in a particular direction, to ignore our own histories and to take off from where the colonial education authorities wanted us to begin from. So I think that African scholars must acknowledge this gap in the first place and not pretend that we have an archive of knowledge. We want to build the archive rather than assume there is an archive. So we have to fill in the gaps, and part of filling in the gaps would be to look at the writings of anthropologists in particular. Whatever view they had, whether it was a Victorian view, whether it was a colonial review, they'll tell you something about what was seen. And you have to deconstruct it, of course, for yourself. But at least there are observations being made about Africans that are living at the margin of their society. They are not condemned, but no one is able to give voice. And I think part of the colonial imprint was to silence that altogether. So there is a gap in knowledge because the advent of the colonial state was the introduction of the regime of gender. That was part of the component, that you're going to be either male and you're going to be either female, but we're going to record this and provide you with a birth certificate. So the provision of a birth certificate becomes an important development in African societies because it then requires them to perform gender because you've got this certificate that is, but we know that there are certain communities in Africa that would only assign gender at puberty. They would not be concerned about the beginnings because in their view, it was difficult to tell which way you would go when you were born. And this would only be revealed at a much later stage. So those societies, and I think I have an article that I can share with you on that point, have been totally erased from history because there was no room for that. There was no room for thinking about gender when someone is 12 or when someone is 13, because it really has to be sorted out at the time that you are born. So I think that if you're thinking of research in this area, the way that colonial authorities developed gender markers and the system that they use to create gender markers is going to be an important part of the discussion. Particularly the birth certificate, because it had to say male or female. And that became a way of requiring you to follow that path that has been. But there are also important writings on how many African societies, and this comes back to your point about language, do not have a distinction between sex and gender. So in a way, part of the weakness of our scholarship is that we already come with terms that require people to separate sex from gender and to perform knowledge, to perform expressions within that paradigm. So I suppose what I'm saying is that, Noah, you have to deconstruct and decolonize. You have got to think backwards. But you will find also that our social scientists on the African continent have not been interested in this. And I think it's a reflection of the colonial education as well. This is seen as an area where you shouldn't be writing anything, you shouldn't be conducting empirical research because it's stigmatized. So we carry that legacy of stigmatization, and we pay a big price because when we cite statistics, we find we don't have enough knowledge. If you look at how knowledge is being developed on transgender now, you probably have statistics in South Africa, because scholars in South Africa have really been researching. They've been going to communities and asking the difficult questions. But in other parts of Africa, it's still a little bit unusual for social scientists to be concerned with that area. So it is really a legacy of our colonial history, and we need to redress that and to accept that although we know that there are Africans who need gender-affirming care, we do not know enough about the need. We can't give figures. We can't give statistics that are reliable. We can give them, but are the statistics reliable? Equally, when we do our census, what are we finding out? Are we not using the traditional markers? Are we really asking the household the right questions? Because unless you have those institutions that collect statistics also acknowledging gender diversity, you are going to find it difficult to discover what Uganda has, what Zimbabwe has. But you will find, I suppose, NGOs with some knowledge. But even the NGOs, they're mainly working on anecdotal evidence. They are working on individual experiences of exclusion, but they're not really going out to say, let's also at the same time look at Uganda as a country and ask the difficult questions, so that we know that in Uganda there is gender diversity. So no wonder our presidents will say, I don't know anyone who is gay in this country, because no one has taken the trouble to say, well, look, President, here are the statistics. This is how your country looks like. So our social scientists are really letting us down. They're not providing the social data that allows us to know and understand. Whatever view you have about sexuality, whatever view you have about gender diversity, at least the point we're making, you should have the information. You should have the social data. If you're going to deny rights, at least do it in the knowledge that in this country, this is our profile. But we don't have that. So the colonial authorities, I think, stymied that development by saying, no, we don't need to worry about this. We shall just use our criminal law to ensure that we all fall into one group, you're either male or you're either female. I don't know whether I've answered your question, but what I will do is to share only one or two articles that might be helpful.
Thank you, Prof. You've answered the question. Thank you so much.
All right.
Great. Thank you so much. And that's very interesting to us. Also, here in the center, we are starting sort of a fledgling project in its infancies where we're trying to document gender diversity across the continent through things that we have read and things we have seen. But a big part of it, as you said, Prof. Ngwena, was that we need to go back to the anthropological texts. And these are texts that were recorded by European colonizers, and we need to deconstruct it. But another question we've started to ask ourselves was that how much value is actually placed on oral tradition and heritage in Africa. And we find that in academia, we are often speaking about decolonizing academia, and yet we do not see oral traditions and oral culture as having some sort of evidence or substantiated in its evidence. Because I think that a lot of the various sexual and gender diversity and identities in Africa are very much based in oral tradition and heritage. So that's something we are also finding very interesting. And also the idea of territories in and of itself, because these territories did not exist prior to colonial regimes, where the borders of Uganda was not the borders of Uganda back in the 1500s. It was an amalgamation of various tribes and various groupings. And that's something as well that we would need to consider and look at. But something, if I could propose a question that I find quite interesting around trans identities, which Prof. Ngwena or Noah, you're welcome to hop in, is to what extent do we pathologize trans and gender diverse identities? Because I think it was previously that transgender was a term under the DSM, or the Diagnostic and Statistics Manual, as a mental illness. And it was only through being in the DSM that folks were able to actually receive gender affirming care. So is that the right way to go, for it to be diagnosed as an illness that requires treatment in order for folks to get better? Or how can we frame trans and gender diverse identities so that it is not seen as an illness that needs therapy, as Prof. Ngwena previously spoke to? I don't know if there's anything you'd like to give feedback to me on, because that's something I've been also thinking about and mulling over.
Okay, I think let's give the last word to Noah, but let me begin by saying that I think part of using the term gender affirming care rather than gender affirming treatment has been very conscious that you are not treating a pathology because of the history of the medicalization of transgender. WHO has moved significantly, as you know, in 2019. It decided to remove transgender from the categorization of pathology to health, meaning there is a health need, but the question you pose is different. Medically, need is preceded by pathology. So it becomes a tension that is always there, that for as long as you want to provide access to care, you have to justify that access. So we talk of care that is necessary and wanted. Care that is necessary and wanted, because those two concepts are so important. Because if we simply say care is necessary, we are implying that you have to have the care, even if you do not need it. So we are thinking, well, how do we provide access? So WHO decided that it won't help not to classify this as a medical need, because it means that we've closed the gap. Particularly if you look about medical cover and insurance, they are not going to, they will welcome the idea that it's a cosmetic need, so that they don't pay for anything. So the World Professional Association of Transgender Health deliberately says this care is necessary and it is wanted in order to enable access. So it is, I think what I'm saying is that context is going to be important. If we are in the context of facilitating access to healthcare, it's going to be difficult to totally remove ourselves from medical disciplines that require a diagnosis first. So what we call that diagnosis, and there must be a way of conceptualizing the diagnosis in such a way that it is not seen as pathologizing. So that is all that I can say. But Noah will have better, I think, ideas than I am.
Thanks, Prof. That's really, really helpful response, and it's a great question too. I would add, I think that the tension, I think you're absolutely right, Prof, about the need to ensure access, and therefore how that informs language. The tension that I'm finding from an implementation perspective is the tension between medical necessity and legal recognition. I find that in many places, as you've mentioned, there is a conflation between gender identity and sexuality in a sense, and therefore, in many countries, the existing homophobia informs an understanding of gender identity as something that needs or requires medical intervention in order to have legal recognition. What does this mean? It means that, for instance, if somebody wants to change their gender marker in a certain place, they might need to show some evidence of medical intervention being done. And of course, while the language of medical necessity, especially in legal documents, ensures, one, that this person is protected and has access to medical services, in some instances, for certain trans communities, as we've mentioned, a distinction between trans, those who might want to access medical interventions, and gender diversity, perhaps those who may not want a certain range or scope of medical interventions. So indeed, there's a tension between the idea of medical requirements and self-determination, for example, whether people are allowed to fully express themselves and claim these identities, or whether having a requirement for medical intervention or having a possibility for medical intervention creates a legal requirement for that intervention to be done before any protection is offered. In simple terms, what I'm saying is, yes, I think Prof is absolutely right about the need to have these services, gender affirming care, couched or envisioned as both as necessary and as a part of not really pathologization, but in need of categorization within medical terms, and I think a constant dialogue or understanding in cultural terms within the law and within society about when that medical necessity becomes a legal requirement. So does an officer sitting at a registration desk for identification have a capacity to be able to interpret that medical requirement? Do they need to know my medical history or background in order to grant me my full dignity in law in terms of either accessing an ID or something like that? And if that's a requirement, how does pathologization offer protection? Because in many ways, sometimes having this as saying, this is a medical need means therefore you can't discriminate against me, versus if it's not a medical need, am I still allowed to get an ID or a name change, even if I've not accessed the medical intervention? I do believe that the protection is necessary, that pathologization in a way does provide access, but I think we do need those ongoing conversations, especially for our broader gender diverse community. Yeah.
I can also add to what you're saying, Noah, as a logical extension. It points to the need for gender recognition laws that clearly spell out that for the purposes of gender markers on identity documents, like what Argentina has done, like what Malta has done, it is not a requirement to first undergo surgery or to first access medical therapies. So I think those countries have deliberately anticipated the need to balance access to care with access to identity documentation, to birth certificate, to IDs. South Africa, sort of scored an own goal because although it has a gender recognition law, that law makes a number of mistakes. First, you have to be either male or female. You can't be non-binary under the South African gender recognition law. Number two, it makes medical certification a precondition. So it's not a good law. It's not a good law. It's not a good example. And in many ways, it could be challenged as unconstitutional because it is imposing an obligation that is discriminatory against gender, transgender and gender diverse communities, requiring them first to be medically certified before they can claim a gender marker. But I think Argentina and Malta are really good examples for us to adopt.
Yes, thank you, Prof, for that. That's exactly what my thoughts were when Noah brought up the need for socioeconomic rights as key outcomes, was because of the fact that in the South African law, you need to first have the medical certificate. However, that means that people need to have access to transport. They need to have access to going to a general practitioner for other psychiatric care. There's so many other requirements first before even to be able to access the legal recognition. And then sometimes you need the legal recognition in order to get as well the medical recognition in some stages, depending on where you are. And it really speaks to how the system in itself is almost broken from the get-go from when it was written. But I think it is 3:30, so I'll close the session and I will say thank you so much for speaking on this. It's a very difficult topic because I think this is one of the cases where we've got excellent jurisprudence and theory around the access to healthcare, or rather the right to healthcare. But when we actually get down into access to healthcare and the practical implications of it, this is where it starts to get very tricky. And that's where it helps to have voices from people such as Noah, who is in organizations where they speak with folks and maybe they themselves have to confront not having access to healthcare in order to be recognized for the equality and dignity that they have inherently as human beings. And so I would like to then hand over to Satang to please just give like a closing, and also for tomorrow morning, just to give information on what is happening in tomorrow morning. But I'd like to just thank everyone again for your contributions, and it is very appreciated.
Please join us in thanking her. Yeah. Thank you. Thank you so much for stepping in at the last minute. And thank you, Noah and Professor Ngwena. And say thank you to everybody that has been online for the whole day. We know it's hard to be, as well as those in person as well. So we'll close for today, and tomorrow we start right on early at 9. Please, for those in person, come before. There's going to be snacks and tea and coffee, I believe. So come. For tomorrow's session, so we'll have the first panel definitely speaking to Professor Ngwena's interest and work as well, which is titled An Intersectional Approach to Sexual and Reproductive Health and Rights, focus on disability, as have been indicated before, as it relates to his work. Then we will have an interactive roundtable that really looks at how Professor Ngwena's impact, especially as it relates to teaching, advocacy, research, and community engagement. And there we'll have several people, including Professor Franz, for example, the special rapporteur on the right to health in relation to the work that she does, as well as Professor Duejaye, and then Yumba, who's also here, as speaking from the student perspective as well. Then finally, I think part of what we also wanted to do with the conference, I think it's twofold, right? So one is really honoring and looking at the state of work as it relates to sexual and reproductive health and rights. But given that we also have folks here, one of the things that we wanted to do was really also have a conversation about the future of sexual and reproductive health and rights. We've obviously already indicated some of the challenges, some of the opportunities, and really tomorrow, as part of, very briefly, we also wanted to take the opportunity to talk about, collaboration strategies, as well as building community of practice, especially as it relates to some of their shared interests as well. And then we have the closing and then a plug finally. Very excited that my book on choice and conscience, lessons from South Africa for a global debate focused on conscience's objection, will be launched by the Special Rapporteur. So all of you that are in person as well are invited for a cocktail. So very excited. And so we'll see you tomorrow, and thank you. See you. Bye. Steve. Thank you.
I can do it for my second.